Okay, just so you know, YouTube is now on.
Mr. Kelleher, I'm now on.
Great. Thank you. And we can hear you.
Very good.
Mr. Broderick.
Mr. Broderick, can you say hello just so we know that your sound is working?
In audio, hello?
Very good. Thank you. And we're still waiting for Attorney Kaplan, right? He did send an email saying they're not on.
Traffic coming in was particularly bad today if he came into Boston. So I don't know if that held him up.
Can you hear me now?
Yes.
Can you speak? I can't hear you.
Are we muted?
Oh, yeah, sorry. I'm gonna have to work on that later. Thanks.
Okay, so I do have a note from Attorney Kaplan saying we are here. You can't see us or hear us. So not sure what we can do about that. Attorney, you can hear us. Can you make sure that you are using the panelist link rather than what's the other link called? Participant link?
Attendees.
Attendee link?
We can promote them, but
And Mr. Green, perhaps you could send that email again with the link to Attorney Kaplan just to make sure he has the right one. We're admitting two sets of attenders to see who they are. Did you say they've raised their hands?
yes.
Okay. We see them. One.
Thank you.
Oh, there we are.
Thank you very much. Sorry about
Welcome.
that. Our link just wasn't working and we were in the public thing, so we could
Okay.
hear everything. You just couldn't hear us. Yes.
Our link
Okay.
did say it was a panelist link, but for some reason we ended up in the public room.
Okay. So, and then is there one other? It's the Michelle down there, right? As well. I assume that's the Bertrands, perhaps?
Yes, it is.
Okay, very good.
we're good.
Okay. So we can begin. On the record, please. Today is,
I'm sorry,
Oh.
just a minute, just a second. I have a technical issue. It's that kind of day. Just a moment.
and if I could just ask if the Salpes are present, if they could raise their hand on the Zoom. They are the non-represented interveners. Okay, so it appears.
Mr. Keller, I've fixed my problem.
Perfect. Okay. Okay, so it appears that the Salpes are not present. We will start. Today is day 2 of the evidentiary hearing for EFSB 25-07. I will briefly discuss a few procedural matters before we resume the examination. Just to talk about what today looks like, we're going to finish up what was listed as day 1 of the schedule. So for the board staff, we have 2 topics. The first is to finish noise, and the second topic is the decommissioning. After the board staff has finished and asking its questions, we plan to move to the town's attorney for him to conduct cross-examination, and then to move to the intervener's attorney to finish cross-examination on the topics that Mr. Ferry did not address on Monday. After we finish, and then Attorney Kaplan will have the opportunity for redirect, and we may have some back and forth on that, but then we'll move on to the day 2 topics. So, I mean, that's the basic overview. And then with day 2, we plan to do the normal format where the board staff will ask its questions after any further direct from Attorney Kaplan, and then the town will ask its questions, and then the interveners, the non-town interveners will ask their questions. So that's the overview for today. We have the motion to strike. We did receive from Attorney Kaplan the non-redacted version of table 6.2. Attorney Pucci, given that development, I'm wondering if you are willing to withdraw the motion to strike, or if you want that to still be considered.
I would like to, so just to confirm, because I was busy getting ready for today and I did not look at what was produced on the reports from Epsilon. Is it a fact that they've been produced entirely in unredacted format, or is there anything redacted, even if it's a date? Is there anything redacted in either of the Epsilon reports that have been produced in these proceedings?
Attorney Kaplan, can I have you respond to that, please?
There is nothing redacted.
Then what I would ask for an accommodation, which you may or may not be willing to grant, but I would be willing to withdraw my motion to strike, and in fact waive that issue if we can have my expert now is away, this week. And I only just got these unredacted reports apparently yesterday. So what I would ask is, as a condition of that, the town just covers any noise cross-examination that it has for next Wednesday on hearing session 5.
I'm just going to go on mute just for 1 second, just to consult. All right. We need to discuss it more, Mr. Pucci, but we will not have a problem having your sound expert testify either next week or possibly the following week.
Oh, no,
But-
I meant my cross-examination of the Epsilon noise expert. And as an alternative to Wednesday, if you're unwilling to give me that, I would ask for a Monday afternoon after we're done with the fire chief.
Wait, you're suggesting on next Wednesday, right? And then in the alternative next Monday.
Yes.
Okay, it'll be either it'll be next week or possibly the following week. But it's fine for you not to conduct it this week.
I very much appreciate that. Then I do withdraw my motion on that representation. Thank you very much. And I withdraw any type of objection to the proceeding related to that issue.
Understood. All right.
Mr. Keller, could I be heard on behalf of the interveners?
Mr. Reich, yes, you may.
Yes. So as you know, Mr. Ferry is out for several weeks. He will be back in town the week of the 16th. It's important for him to, we don't have an expert. We're relying on the town's expert. And so it's important for Mr. Ferry to be able to consult with the town's expert and frankly, hear the town's experts examination so that he can ask any further questions that Mr. Pucci hasn't covered of the noise expert when he returns.
I hear you. Thank you. Are there any other procedural matters that need to be discussed before we begin the further cross-examination on the noise issue by the board staff? Mr. Chang, if you would.
Mr. Presiding Officer, there was just one question that I had, because the cases that I've tried before your board have been, sometimes I've been in, I think, the room that you're in. Sometimes it's been remote. Sometimes it's been a combination. I just wanted to confirm, are the questions from siting board staff just siting board staff, or is there also DPU questions? I just wanted to get clarity on that because on other ones, you know, the siting board staff had quite a few questions. I was just curious about how this proceeding is being done in terms of DPU and siting board. And it's not an objection or anything. It's just out of curiosity.
I would say it's entirely the siting board staff that is asking these questions.
Thank you very much. I appreciate that.
You're welcome. Mr. Chang.
Thank you, Hearing Officer Kelleher. So I will continue the question to the company's expert panel. Please refer to Exhibit EFSB-OAK-74.
E4.
EFSB-OAK-74.
Thank you.
I'm asking. A lot of sound wall. Oh, sorry. 74.
Yes. Yes, we're there.
I'm sorry, who said that, please?
This is Ryan Callahan.
Thank you.
So in the exhibit, the company stated that the dimensions of the sound wall is approximately 21 feet tall and 815 feet long. My question is, what is the estimated thickness of the sound wall?
So the thickness of the sound wall isn't a locked-in value. What's important with any sound wall is that it meets the required density or STC value, sound transmission class. It needs to be built of sufficient density to where it will block a significant portion of the sound. And for the purposes of this project, a wall with an STC value of 35 or higher would achieve that. It also needs to not have any cracks or gaps. Needs to be a solid wall that you can't see through. It's not a typical fence or something like that. It's a more substantial structure than that.
Thank you. So when will the thickness be determined during the construction of the project?
Typically, as the site design advances, a particular sound wall vendor would be chosen. And then those discussions would happen with the company, and they would determine what material, what specific product would be selected. So that would occur later in the design process.
Thank you. Could you elaborate a little bit on the type of materials that the sound wall could be made of?
For the purposes of sound reduction, the material could be any number of things. It could be wood, it could be fiberglass, it could be a masonry product. There are a number of materials that are available that would achieve the reductions necessary for the project.
Okay. So hearing from the response in the earlier question, would the company anticipate this sound wall design to change as project design progresses, such as a result in the final equipment selection? So like as a final best equipment selection or transformer selection, because of in response to the noise levels.
This is Brian Benito from the company. The company anticipates that there could be those changes associated with the final design of the facility.
Thank you. Now, please refer to Exhibit MS-C, which is the sound report, and EFSB-OAK-72.
Yes, I have that.
Thank you. The first question, in table 6-3 shows a 10 dBA increase in sound level at a nearby residence, which is designated as R10, and an 8 or 9 dBA increases at in several others.
I'm sorry, 8 or 9 dB increases what?
At several other residences. Given that there are multiple factors in place, such as equipment selection, fan throttling, and sound wall height, is there any possibility for the actual noise profile of the project in operation exceeding the model sound levels and the sound increase threshold of the Mass DEP noise policy?
No. So the important thing to understand is how the ambient sound levels and then how the acoustic modeling were conducted in order to arrive at those values you just stated. The ambient sound levels were based on the quietest nighttime periods, which occur typically between midnight and 3 a.m. The modeling was based on the maximum sound levels from the project operating at the 40% fan throttle, which was established on the previous hearing day to occur under a 98-degree temperature, which would not occur in the middle of the night. So it's an extremely conservative comparison of assuming the project will operate at that highest level and then comparing that highest level to those middle of the night values. In addition, there are several other conservative assumptions in the modeling that assure that the modeling predictions are overly conservative.
Thank you. Well, I understand what you just said. However, if there's any scenarios in which post-construction project operation sound levels were found to have exceed the Mass DEP noise policy thresholds, what additional noise mitigation could the company implement at that time?
There are several other mitigation measures that could be implemented, such as additional fan throttling, operational restrictions, additional sound barrier walls, quieter equipment.
So you did mention a little bit on the operational side of things. How flexible would those additional mitigations be for the company to implement if there is ever such a scenario?
So the project has to comply with the state noise policy. So it would need to determine a way to operate in that manner.
Okay. Based on that information, I understand that any exceedance of noise level beyond the policy threshold is unlikely. And the company have stated that it does not anticipate conducting a sound assessment after the BESS is installed. Now, I understand, however, there are residents nearby and residences nearby, and residents would still be concerned about sound level. Would the company be open to conducting some construction noise study and potentially also if there are any augmentation to the project later on to conduct another sound monitoring, I would suppose, to make sure the noise level are within what we permitted in this proceeding?
Yes, the company would be receptive to conducting post-construction noise monitoring to ensure compliance with the Mass DEP guidance. That's applicable at that time.
Thank you very much. Now, please refer to Exhibit OAK-11.
While folks are, Mr. Presiding Officer, while folks are looking at their materials, can we just confirm who we have in the room today with the company and council? I see 3 people at the witness table, and I see Andrew.
You also have Eben Albert from Pierce Atwood on behalf of the company in the room, in addition to Andrew and the 3 witnesses.
And the 3 witnesses are Ryan Callahan for noise, Mark Bergeron, and Brian Benito.
Thanks very much.
And we do have our Assistant Director.
You know, and Mr. Albert,
Oh,
if you could swing the camera slightly, just so that Mr. Callahan is visible and you are visible as well.
yeah, and
Okay there.
You could be improved slightly.
I can't move it over any further. So I can
Okay,
only,
then-
oh, there it goes. Yeah, how's that?
That's great. Thank you. Go ahead, Mr. Cheng.
So referring to OAK 11. In response to the siting board's information request, the town stated that it would seek to impose construction, delivery, and activity limits to within the time period of 9 a.m. to 5 p.m. for the overarching construction time envelope. Will such normal construction work hours work for the project construction as well?
Yes, as the company has indicated, construction hours between Monday and Friday, the hours of 7 a.m. to 5 p.m. would be a typical standard construction window for us.
Let me clarify. The town is suggesting 9 a.m. to 5 p.m. Would that work for the company?
The company would prefer to stay with the identified 7 a.m. to 5 p.m. window. This window is in line with the town's standard noise operating time parameters.
Thank you. I will note there is a differences there, perhaps to work out later between the company and the town. I'll move on to my to a second part of my question. The town also expressed concern about noise disturbance of children doing their schoolwork at the Oakham Center School and would require the company and its contractor refrain from any deliveries and activity as well as any excessive noise between the hours of 9 a.m. to 2:30 p.m. that could be heard at the Oakham Center School. Would such noise restriction between the 9 a.m. and 2:30 p.m. work for the project construction? And please explain why or why not.
Yes, the company, as proposed, construction hours would be Monday through Friday, 7 a.m. to 5 p.m. Having those restrictions, time restrictions on the project would create a logistical and very challenging environment for us to complete the scheduled project construction. I would also like to note that the Monday through Friday, 7 a.m. to 5 p.m. was pulled directly from the town's bylaw.
So just to get your answer right, so your answer is no, the company, that would not work for the company.
Yes, that is correct.
Thank you. The next question, we're referring to the same exhibit, but in addition, also exhibit INT-16 and EFSB-NO-5.
Okay, we have those.
In exhibit INT-16, the company provide a range of sound levels at different distances from a construction noise source that is 85 dBA at 50 feet, and which is based on the loudest piece of construction equipment identified by the company in exhibit EFSB-NO-5. The sound levels of the construction noise, let me repeat that. The sound levels of construction noise source range from 79 dBA at 100 feet to 59 dBA at 1,000 feet. My question is, what would be the closest distance that any such construction noise source would be located from Oakham Center School during any stage of the project construction?
I believe off the top of mind, as the crow flies, the construction site is approximately a little over 1 mile from Oakham Center School.
Thank you. So based on that distance, what would be the sound levels from the construction noise source at the center school?
So if that school is approximately 1 mile away, that would represent another 2 doublings of distance from our largest value in INT-16. So every time there's a doubling of distance, there's approximately 6 dBA of reduction. So if we went from 1,000 feet to 2,000 feet, that would be approximately 53 dBA. And if we went from 2,000 feet to 4,000 feet, that would be approximately 47 dBA. So my answer would be lower than 47 dBA at 1 mile.
Thank you. The following questions you may need more time to calculate, but if so, we can look at a record request. But if you are able to do the calculation, that would be great as well. What will be the sound levels at this distance? We're talking about 1 mile. In the following scenarios, if the receptor is inside a building with windows closed, and the second scenario is if the receptor is inside a building with windows open.
If we use the previously mentioned value of 47 dBA, that's an outdoor value. A typical outdoor to indoor reduction is about 20 decibels. So that would mean the indoor sound level would be approximately 27 decibels. If the windows were open, you would still have a reduction of approximately 10 decibels, and therefore the 47 would be reduced to 37. For context, a sound level of 35 is approximately what a library is inside of a library. So we're talking about levels of approximately a library or significantly quieter than a library.
Thank you. I understand you mentioned the library, but just for the record, please describe the common noises. Let me rephrase that. What might be the potential noise impact on school instruction with these, like, so the 3 sound levels?
At those sound levels, I would not anticipate an impact inside of a school building.
Thank you very much. We'll now move on to this decommissioning and project design questions.
Just 1 second. Can we confer?
Sorry. So my colleague just checked on Google Map and find that the distance might not be a mile. I would like the company to double check and update the testimony regarding the sound levels so that we have the accurate information on record.
Okay,
Starting with the distances, and then also if there are any modification to the sound levels outdoor and the 2 scenarios indoor.
Okay, understood. Is there a record request number we can assign to that?
Yes, it will be RR-EFSB-3.
And I can come up with the language. There's a request for the company to submit a measurement of the distance from the construction site to the Oakham Center School and the anticipated sound levels due to the project construction outdoor, and in the second scenario is indoor with the windows open, and a third scenario indoor with the windows closed. And a second part to the question again, discuss any potential noise impact on school instruction due to these sound levels. Thank you, hearing officer.
Mr. Chang, I assume may continue.
Thank you. For the next question, please refer to Exhibit OAK-21.
Sean. Sure. We have OAK-21.
Okay. Did the company validate the turning radii of emergency vehicles with the Oakham Fire Department, including conducting a sweep path analysis from the entrance?
I'm sorry, including conducting a what?
A sweep path analysis from the entrance of the project parcel to the BESS facility?
Yes, I can confirm our engineers have done that exercise from Cold Spring Road to the batteries.
Does that study also include the turning into the site from the road?
Yes.
And can you, for reference, point to the exhibit that has such information?
We could submit that. I do not believe it has been submitted yet.
Okay. So I would like to another record request.
This will be RR-EFSB-4.
Would like the company to submit the sweep path analysis from Cold Spring. Oh, what is it?
Holbrook.
Oh, Holbrook Road to the site of the BESS facility, including showing the turn from the road into the project site.
Understood. Thank you.
You may continue. Thank you.
Next, we will refer to Exhibit EFSB-D-4.
Yeah, this is Mark Bergeron. We have that exhibit up.
Okay. What equipment has the company finalized, and what equipment has the company not finalized?
I think we're actually looking at the wrong exhibit. I apologize. Could you provide that reference again?
So if it is EFSB dash D as in Daniel
Okay.
-4.
Thank you. Apologize for the delay.
Okay, I have EFSB-D-4.
Thank you.
Could you repeat the question?
Certainly. What equipment has the company finalized and not finalized?
At this stage of design, the company has not finalized any equipment.
So for all equipments that are not finalized, would the company anticipate being able to produce that information at least 90 days prior to the start of construction? And specifically, we'll be looking for the final equipment details, any changes to the environmental impacts resulting from the final equipment selection that differ from the impact assessed in this
I'm sorry, from
proceeding.
the final equipment selection that what?
Differ.
Defer?
Differ.
Oh, thank you.
From the impacts assessed in the proceeding with any supporting study and documentation, as well as any proposed mitigation corresponding to such changes.
The company would not have a problem providing the final equipment 90 days before construction.
Thank you.
And those associated increases or decreases in impacts of resources.
Thank you very much. I'll next refer to Exhibit EFSB-G-20.
I have EFSB-G-20.
G as in general, right?
Yes, sir. Golf. Yep.
Okay.
General.
Does the company anticipate that it can prepare and submit a draft or finalized version of a decommissioning plan for this project alongside an update on decommissioning bond or other suitable financial mechanism at least 90 days prior to the start of construction? Please explain why or when. Oh, never mind. I'll leave that in case you say no, but.
Yes, the company would be able to provide that 90 days before construction.
Thank you. Hearing officer, that concludes my questioning on these topics.
Thank you, Mr. Chang. I think we can continue. Mr. Pucci, would you begin your questioning, please?
Yes. My questions today will be, I think, mainly to Mr. Benito, but obviously anybody from the panel can weigh in as they see fit. Good morning, sir. My name is George Pucci, and I represent the town of Oakham in the siting board proceeding that we're here for today. My first questions have to do with site selection. Some in follow-up to what you were asked on Monday and some new. Before that, please describe your educational background, starting with higher ed after you graduated from high school.
That information is in my pre-filed testimony. However, at a high level, my higher education consists of an undergraduate degree in environmental studies, a master's degree in environmental education, and another master's and a subsequent master's degree in business.
And do you have any other degrees or certifications?
Do not have any other degrees or certifications.
What is your work history post graduate school up to today?
My work history post-graduate school up to today has consisted of working in energy in various forms, initially starting with transmission and distribution at an investor-owned utility here in New England. Subsequent to that, I worked for a natural gas pipeline company out of Texas here in the Northeast. Subsequent to that, I worked in offshore wind in North Carolina, Virginia, New Jersey, and New York, off the coast, obviously. After that,
I'm sorry, in New York, what?
off the coast of those states.
Did you finish your answer?
No. Subsequent to that, I spent time doing onshore wind in Western New York. And subsequent to that, I've been in this current role for the past 13 months.
I just want to break it down with a little more accuracy in terms of timeline. And the reason for my questions is, I'm getting at the issue of your experience specific to being qualified to find a suitable site for a large-scale BESS facility of 180 megawatts, okay? So why don't we start again in post-grad school? Can you tell us your approximate dates of employment, who the company was you worked for, and what your duties and responsibilities were for that company?
As shown on my pre-filing testimony and CV, immediately following and running concurrent with my master's program, I was at Eversource Energy from 2009 to 2015. I was at Kinder Morgan from 2015 to 2019. I was in offshore wind from 2019 until 2024. I was onshore wind in 2024. And since 2024, I've been in renewable energy, specifically in this role since February of 2025.
That's helpful. Thank you. What were your job duties for Eversource in between 09 and 15?
My job duties in Eversource comprised of me reviewing major infrastructure projects such as greenfield development of substations and high voltage transmission lines.
Where did you work from? Where did your project work? Did it involve any particular area of the country?
My roles and responsibilities were in the state of Connecticut, Western Massachusetts, and Western Massachusetts.
Did any of that employment involve operations of such facilities?
Yes, I was also responsible for ensuring environmental compliance with local, state, and federal regulations for facilities that were operating that had a need for maintenance and or a capital project associated with a increase in or a change in that operating asset.
About 2015 to 2019, what was the nature of your employment then?
I was responsible for FERC 7C projects in particular. I focused on a project in Western Massachusetts, Northern Connecticut, and Eastern New York as my primary project. I also had multiple projects in the state of Texas.
I saw the stenographer look up into the air. I think you said FERC, right? F-E-R-C.
F-E-R-C, correct.
Refers to what does that refer to?
Refers to the Natural Gas Act in the subsection of the Natural Gas Act that regulated interstate natural gas pipeline development.
So it's federal statutory scheme, correct?
I'm
Yes.
sorry, I didn't understand you, Mr. Pucci. So it's federal what?
It's a federal statutory scheme, correct?
No, that's what he asked you. I think Mr. Bucci asked what does FERC stand for, and Mr. Benito, I think you know what that stands for.
Yes,
Okay.
it's the Federal Energy Regulatory Commission.
How about 2019 to 2024? What did you do with respect to offshore wind projects?
I led the development of all, I was responsible for all local, state, and federal permits for those offshore wind assets and ancillary onshore assets.
What projects can you identify for us? Anything specifically?
Specifically, I was responsible for the Kitty Hawk offshore wind project located off the coast of North Carolina and Virginia. I was also responsible for Attentive Energy 1 and 2.
I'm sorry, I was also responsible for what?
Attentive Energy 1 and 2 in the states of New Jersey and New York.
Did any of those projects involve battery energy storage facilities?
Those projects were offshore wind development, standalone offshore wind development projects.
Where was the interconnection point for those offshore wind projects?
The interconnection point for those offshore wind projects was located onshore, typically as close to the coast as we could find.
Yeah, can you tell us about any of them? That, you know, like what town they were in, what state?
The project Kitty Hawk offshore, the onshore infrastructure was in Virginia Beach, Virginia. For Attentive Energy 1 and 2, the onshore infrastructure was at Ravenswood Generating Plant in Queens, New York. And the project off the coast of New Jersey, the interconnection location was identified by the state of New Jersey through a RFP, which was at a
I'm sorry, through a what?
request for proposal process that identified the interconnection location being on a military installation on the coast.
And your oversight responsibilities, was that strictly with respect to the offshore portion, or did it go over to the interconnection points on land?
I was responsible offshore to the POI.
What is the PO?
To the point of interconnection.
Okay. And how about infrastructure related to the interconnection itself? Did you have oversight responsibility over any of those components?
I did.
Okay. Can you describe that for us? Just tell us what your responsibilities were for these projects. This is now 2019 to 2024. Like your day-to-day.
Yes, my day-to-day involved oversight of subject matter experts conducting field surveys, natural resource delineations, route reviews, alternatives, site selection, and then all associated permitting at the local, state, and federal level.
And your actual employer for that is reflected in your CV with your pre-filed testimony, correct?
Correct.
Okay. And then how about onshore wind in 24? What did you do for that?
My role there was to run a land campaign where I was out prospecting for land to develop wind turbines and associated infrastructure on.
How about your day-to-day for that? First of all, how long did that employment last, and what did it lead to?
That employment and that campaign lasted approximately 90 days, and my day-to-day was driving around Western New York, knocking on doors and talking to landowners to introduce them to the possibility and the opportunity to have wind turbines and or ancillary services on their properties.
And did anything result, did any projects result as a result of that interaction?
I am no longer with that company. I do not know what their level of development in that opportunity was. My role was to secure 750 acres of land, which I did across 10 properties.
From private property owners?
Yes.
Okay. And now bring us up to the present. So you were involved in renewable energy since February of 2025. Please describe that for us.
Well, as just indicated, I've been involved in renewable energy since 2019. Starting in 2025, I was brought on to Rhineland Energy to be the Vice President of Development. This role consists of me ensuring that we are working through the state, local, and federal approvals to get these projects cited and permitted.
And what projects are you referring to?
I'm referring to the Moraga Storage Project in this proceeding, as well as other projects in the portfolio here in ISO New England.
Yeah, I had some follow-up questions on that from Monday. I was confused about the nature of the other projects. I will get to that in a second. When Attorney Ferry asked you on Monday, well, actually, let me back up a second. Based on your education and experience in this field, do you consider yourself an expert in site selection for an alternative energy project such as a battery energy storage facility?
I do consider myself a subject matter expert on developing major infrastructure projects in the energy industry.
And now I wanted to break it down into some of the factors that go into that analysis. When Attorney Ferry asked you on Monday what factors were of importance to you in selecting the Oakham site, you stated that one of the factors was that it involved, quote, minimal impact to environmental resources, close quote. Is that correct?
That is correct.
And just let me shut my door for a moment because I'm trying to be loud for the stenographer and I don't want to drive my neighbors crazy. Okay. Sorry about that. I just want to keep my voice up.
Before Mr. Pucci, sorry, I just wanted to let you know that Mr. Salalico, another your Satwood attorney, came into the room.
Okay, great, thanks. Before I ask questions about that issue of minimal impact to environmental resources, on Monday, the presiding officer asked if there had been any updates on the project schedule. One of your updates was that while you had initially planned to file a notice of intent with the Oakham Conservation Commission in January 2026, that filing had not yet been made. My question is, what is the anticipated filing date for that now?
The anticipated filing date for that local NOI permit would be coinciding with the conclusion of this proceeding.
What is the reason for that?
The reason for that is, as is standard in projects of this size, scope, and nature, it's most preferred to ensure that you're not filing subsequent project plans or applying for subsequent permits if there's the possibility of a site design or modification.
So you're waiting to see how the siting board rules before you finalize the plan? Is that it?
Yes, we are waiting to ensure that there will be no more design changes necessary before going and submitting those plans for permitting purposes.
What if design changes come as a result of the conservation notice of intent process?
The conservation notice of intent process, the notice of intent will be reviewing impacts to wetland resources. Those impacts, the Conservation Commission will be looking for us to avoid, minimize, or mitigate those impacts. We believe we've preemptively done that with the revised site plan that we are reviewing in this proceeding.
So basically that revised site plan is sort of a take it or leave it to the Conservation Commission. Is that what you're saying?
I would never want to say that. That is the current site plan that we are operating and working through this proceeding on, and it represents, in our opinion, the most optimized and minimally impactful development on the subject property.
Have you been involved in other applications for approval under the Massachusetts Wetlands Protection Act?
I have.
What projects?
Numerous projects.
Well, why don't you tell us about them? Massachusetts Wetlands Protection Act. How many?
Sir, I've got a long career going back to 2009, working in this industry, and I would not be able to list off the close to likely 100+ projects at this point in my career.
Are you saying that you've been involved in 100+ projects requiring approval under the Massachusetts Wetlands Protection Act?
I'm saying I've been involved in 100+ projects that have required review of the Massachusetts Wetland Protection Act. Yes.
The projects that you described sounded like they were offshore wind. One was in Virginia, some involved New York. I didn't hear much that required permitting under the Massachusetts Wetlands Protection Act, other than maybe the project that you're seeking approval for now. Is that right or wrong?
That is wrong.
Okay. But can you name any, even if?
I can name the projects that I worked for when I was doing this, as mentioned, in Western Massachusetts for the Western Massachusetts Electric Company, or WMECO, or Eversource Energy.
So that would be the universe of projects that would have required permitting under the Massachusetts Wetlands Protection Act?
That's correct.
Okay. All right. I understand. Well, based on your experience, isn't it a common occurrence that plan changes will come as the result of a hearing process on a notice of intent?
That is not my understanding.
Do you think that? Sorry.
Typically, as previously testified, before we go to a permitting authority like the Conservation Commission, we will have, through our subject matter experts, through receiving feedback that's garnered through open houses and other means, have already refined our project to the point where we feel comfortable presenting it to a permitting authority. And as such, those projects typically do not have major modifications associated with them.
Did you speak to Mr. Bergeron with regard to his experience on notices of intent on projects that also require siting board approval?
Yes, I've worked with Mr. Bergeron and his firm for well over a decade. I am quite familiar with Mr. Bergeron's additional activities as a conservation commissioner himself and as a chairman of the Massachusetts Association of Conservation Commissioners.
And did he, well, he can answer for himself. Is that your position, Mr. Bergeron, that the notice of intent should only be filed after the siting board proceedings are concluded?
Yes. Typically, we would advise our clients in a proceeding at the Mass Energy Facility Siting Board, especially one where there is active intervention and the potential to hear feedback during the evidentiary hearing process. So both the public open house, the discovery portion of this process, and the evidentiary hearings offer the applicant and our team the ability to hear additional concerns in detail, potentially hear from expert testimony, and make some decisions on refining and maybe even modifying the project design coming out of evidentiary hearings before we file. It gives the opportunity to then modify the design. If there's anything that we heard that we may want to address, that's a concern that we know we can incorporate into the design. Leaving evidentiary hearings, we'll meet with the engineering team, talk about any additional potential modifications.
I'm sorry, I can't understand you. There's a concern that we know we can incorporate into design, leaving evidentiary hearings. What?
If there are any changes that we heard during evidentiary hearings, we can then incorporate those design changes into the plans that we can prepare for permitting and bring that to the notice of intent application at the local conservation commission. Rather than, sorry, Mr. Pucci.
I'm sorry, I didn't mean to interrupt. Go ahead.
Rather than filing an application prior to these proceedings, hearing additional information and trying to make those changes while we're in these proceedings.
Haven't you been involved with other permit filings that the notice of intent either ran concurrently with or was filed prior to the siting board proceedings, either going forward or when they were ongoing?
I can't recall any particular energy project that has had to go through the Mass Energy Facility Siting Board process that I've been involved with, where we have filed a notice of intent concurrent with the process. One in particular that sticks out to me is the Sudbury to Hudson transmission reliability project, where we again took the same tactic of waiting to file our notice of intent until after the evidentiary hearings for the purposes that I described previously, and we made some additional engineering changes. We've also been involved with at least a dozen other cases where I believe we followed the same order of operations from permitting in those cases as well.
In that Sudbury matter, wasn't the amount of environmental information in terms of mapping and resource areas, site visits, wasn't that much more fully developed in that case than the state of the environmental related review in this case?
No, it actually was at the exact same level of detail as this case, in that the strategy on that project was to file an abbreviated notice of resource area determination or delineation, and receive an order of resource area delineation, which would then set all of
I'm sorry, and received a what?
An order of resource area delineation, which would then set the jurisdictional limits of wetland resource areas. We did the same thing on this project. We filed that ANRAD application, ANRAD, and have received an order of resource area determination from the Oakham Conservation Commission. And so we are at the same level of detail on this particular project that we were on many of the former projects that I've discussed.
Are you saying that, first of all, on the ANRAD, that's a topic for a different day. So I'm going to ask you quite a few questions about that, which I'm not going to get into now because they're not, specific to site selection and project design issues. Are you saying that the Sudbury project was at only a 30% design level at the stage you were at before the EFSB in that matter?
Yes, I mean, all of the projects that I've worked on, including this one, are at this same level of design prior to going into your permitting drawings and advancing your design to for permitting. Again, the 30% design, it's a commonly used term in the industry, but there's really no standard of what defines a 30% design. So at this point, this particular project, has full site civil grading, has
I'm sorry, with this particular project, what?
Has full site civil grading design. It has designed a stormwater management system that can show compliance with all of the standards and shows the all limits of work and footprint proposed for the project.
Did you finish your answer?
Yes, sir.
Okay, I appreciate that. And I just want to note for the presiding officer, I have a lot of questions related to environmental issues, and I do not intend to ask those today, except as they may relate to site selection. So I just want to note for the record, I'm not done with this line of inquiry with Mr. Bergeron. But moving on, and this is a question for the panel. Anybody can answer it, including Mr. Bergeron. What was the reason the company put in a date, both in their discovery responses in this matter and on the Gantt chart, that a notice of intent with the Oakham Conservation Commission was going to be filed by January of 2026, which is 2 months ago?
We had, I believe, when we filled out that IR, we had the schedule for these proceedings in our view would have been a little bit sooner than where we are at this time.
But that's the only reason?
It's the only reason I can recall.
There's a question also for the panel. Maybe it's for Mr. Bergeron, because I'm asking it in specific relation to the Sudbury matter that you testified in. That was a different type of scenario, wasn't it? In that, and this is kind of a long question, so just let me finish it. Isn't that a different type of proceeding in that you contemplated going through the siting board process, going through a full NOI process, and then, if necessary, proceeding to the certificate of environmental impact process, depending on what happened with Conservation Commission? Is that fair?
Yeah, that outlines the process of order of operations that we contemplated for that project, yes.
Yeah, and in fact...
Forgive me, I'm sorry. I'm hearing most of the words you're saying, but not all of them. Again,
I'm sorry. I'll speak up. Yes, that's correct.
And Mr. Brock, are you talking about me or the witness?
No, the witness.
Okay.
I'm hearing you loud and clear.
All right. I apologize for the sound of my voice.
No, it's
right.
great. Thanks.
Okay. Yeah, and on that, staying on that same project in Sudbury, you actually did get the order of conditions from the Conservation Commission without issue, correct?
Yes, that's correct. Sometime after we completed the evidentiary hearing process for those proceedings.
Yeah, no, my questioning is on a sort of a different subject matter, not so much the sequencing, but so to complete it on the Sudbury project, you never had to get to that stage that you had to seek a certificate of environmental impact to essentially override any type of appellate process involving the notice of intent and order of conditions, correct? In other words, that was done. That was a box that you could check off at that point.
That's correct.
And in this case, what's different is, and this is again to the panel, it's been represented by the company that you're under some type of expedited process so that you can get to the certificate of environmental impact stage immediately following this proceeding. Is that right?
So I'll just interject here and say I believe that is a legal question that you're asking. The company has reserved its option to do so. It doesn't have to go for the certificate.
Yeah, well, let's have the witnesses answer.
Well, I don't know.
In this case,
I don't know if the witnesses can answer that question, so maybe you can rephrase it.
No, I don't want to rephrase
part of the legal,
it.
well, then I object. Then the witness they cannot answer the question as to whether or not under the statute we're entitled or will go for a certificate. So the witnesses cannot answer that question.
The witness can answer the question. Mr.
Witness
Presiding
cannot
Officer, I
answer
would
the
just,
question. I'm instructing the witness not to answer the question because you have any, you can
I'm
ask
not
them if they
seeking a
have.
dialogue. I'm
So
not
let me
seeking a
just, let
dialogue.
me,
Wait, one at a time, please, just a moment.
Sorry, I'm not seeking a dialogue with you, Andrew. I want a ruling from the presiding officer.
That's fine.
Mr. Kaplan, what is I hear you saying they can't, but what is the basis for your objection?
The question is, and let me go back and just.
No, I heard the question, but
Oh,
just
so
the basis for your objection.
the question is, why would, maybe Mr. Pucci can state the question, and let me see if I can review that. I've got a number of things that I'm looking at here on the transcript. Mr. Pucci said, and in this case, it's different, and this again is to the panel. It's been represented by the company that you're under some type of expedited process so that you can get to the certificate of environmental impact stage immediately following this proceeding. Is that correct? Want to answer that?
I'm under the advisement.
No, you can answer that.
I can answer that. The question is, are we gonna get a certificate?
No, the question is,
My question is my question. So
right,
I'd like an answer.
I'm reading the question. The question is, it's been represented by the company that you're under some type of expedited process so that you can get to the certificate of environmental impact stage immediately following this proceeding. Is that correct? Yes or no?
I am not aware of the expedited process that's being asked in this question. Is the expedited process this hearing? I don't understand the question. I apologize. I would like to be helpful, but if you're asking me if the company's position is that we have an expedited process, we filed this comprehensive zoning exemption almost a year ago, and in my opinion, this is not expedited. This is standard operating procedure.
The company has requested the schedule that the siting board has ordered in this case so that it can get to the stage of the certificate of environmental impact, correct?
My belief is that my understanding is that we have spoken throughout this process to reserve our right to go to that process that you are laying out in your question.
Okay.
And as such, to ensure that we have the opportunity to exercise our rights under the rules and regulations as I understand them, that the schedule needed to be finalized or agreed upon that would allow the company to exercise that certificate process if needed.
So where are you intending to squeeze in a notice of intent to the Conservation Commission under the Massachusetts Wetlands Protection Act and a full hearing on the notice of intent and then an order of conditions, either approving the project with conditions or denying it? Where are you planning on squeezing that in to this process?
As previously testified, it's our expectation that we will be filing a notice of intent with the local Conservation Commission shortly thereafter these proceedings conclude.
So when you get a citing, when you say when these proceedings conclude, you don't mean the evidentiary portion, you mean an actual final decision from the full citing board, correct?
I mean, as we testified before and as my subject matter expert has testified to multiple questions asked, following this evidentiary hearing.
Oh, the evidentiary hearing,
Shortly thereafter, this evidentiary hearing as previously testified by myself and my subject matter expert, Mr. Bergeron.
So then sometime in March.
I don't have the actual schedule or in front of me of when this proceeding will end, but hopefully this proceeding will end in sometime in March. Yes.
Yeah, let me help you out. The scheduled fifth day of this hearing is scheduled right now for a week from today. That's in March. There is also another additional day contemplated depending on, how these go, if there's a need for for a sixth day of an evidentiary hearing, but clearly in March. So if the evidentiary hearing concludes in March, are you saying under oath today that you are filing your notice of intent with the Oakham Conservation Commission in March at the conclusion of the evidentiary hearing?
No, I am not saying that.
What are you saying?
I am saying that at the conclusion of the evidentiary hearing, I will go back with my team. We will gather up all of this information. We will then discuss with our design team if any changes need to be made to the site layout. Then we will begin to put together the notice of intent package. That package itself will take a few days or weeks to actually get drafted by my subject matter experts. Then it will have to go.
I'm sorry, that package itself will take a few days or weeks to what?
By my subject matter expert, Epsilon, and then it will come back to me where I will have to review it, and that may take a few days or weeks itself. At that point, then we will be in a position to file that NOI.
That's okay. That's helpful. So if the evidentiary hearing concludes in March, as is anticipated, are you anticipating under oath today with Mr. Bergeron next to you that you're going to be in the position to file your notice of intent with the Oakham Conservation Commission sometime in April of 2026?
I would not be able to say that. I think that an appropriate timeline may be 60 days, give or take, post this hearing.
Okay.
60 days would be an appropriate time for us to go through the process I just laid out.
So maybe in April, but certainly no later than May. Is that fair to say?
Based on this testimony I've just provided, that's fair to say.
Is that Mr. Bergeron's testimony as well?
Yes.
Okay. Now the other update that you provided on Monday was an anticipated filing with the Commonwealth of Massachusetts Department of Conservation and Recreation, correct?
That is correct.
And what is the nature of that anticipated filing?
That filing, it would be anticipated to follow along the same timeline I just outlined for the NOI.
No, I didn't ask the timeline. I asked what is the nature of the filing?
Perhaps Mr. Bergeron will be better to answer that question.
I can, thank you.
Did you say you can or can't? I'm sorry.
I can, sir. Just
Okay.
I want to find
Okay, thanks.
the response so that I give you the proper answer.
Yeah, I'm not trying to rush you. I just didn't know what you said. Thanks.
So the nature of that filing is what the Massachusetts Department of Conservation and Recreation defines as a determination of applicability under the Massachusetts Watershed Protection Act.
Okay, what is it for? Like, just tell us in plain English what the filing is for, what they're reviewing, what you're seeking approval for.
What they will review is they will review all of the proposed project activities within the Ware River watershed, which is a watershed that is protected under the Massachusetts Watershed Protection Act. The determination of applicability will be for them to decide if the project as designed will have no effect or minimal effect on the potential to impact that water supply. You know, in essence, they will determine if it's been designed, you know, with all appropriate compliance measures and mitigation measures, protection measures, or they will determine that the project needs to undergo additional review and potential modification through an additional permit-related process with the Department of Conservation and Recreation under the Massachusetts Watershed Protection Act.
So my questions earlier about plan changes possibly coming as a result of the NOI process before the Oakham Conservation Commission, you all answered those questions. And you're basically claiming you're not anticipating plan changes coming as a result of that. That's why you're waiting until these proceedings conclude before you go ahead with that filing. the DCR process seems to be a different process, right? There could very well be plan changes as a result of that review. Is that fair to say?
I think that would be fair to say. However,
yeah.
we have designed this project, in particular the access, the proposed access route through that Ware River watershed with compliance of those regulations that Mr. Bergeron just laid out in mind.
I guess my question is, a different rationale would apply for delaying that filing. It seems that the reason that you're claiming you've delayed the Conservation Commission filing would not apply to the DCR filing. In other words, it would make sense for that proceeding to be underway prior to or concurrent with these proceedings. Is that fair?
With all due respect, sir, we are not delaying any of this proceeding or filings or applications or permits. We are right now hyper focused on these hearings and preparing for these hearings and addressing over 400 IRs. So frankly, there's been no delay or malicious or otherwise for how we are proposing to go forward with those two regulatory agencies that you have mentioned.
Yeah, I wasn't trying to be argumentative with my use of the word delay. So let me try to rephrase the question. The rationale that you stated for not having proceeded with the NOI before the Conservation Commission, that rationale does not appear to apply to the situation with the DCR review. Is that fair to say?
That is not fair to say.
Tell me why that's different, because I thought you just said that plan changes could come as a result of the DCR process.
I believe what Mr. Bergeron was saying is that the DCR has multiple determinations that they can make based off of the plans provided to them at the time of filing.
Mr. Pucci, this is Mark Bergeron. I'm happy to clarify a little bit. It's the same rationale. There are proposed portions of this project, such as portions of the proposed access roadway that traverse through the area subject to jurisdiction under the Watershed Protection Act, which DCR would be the issuing authority. So much like, and actually exactly like, the rationale for holding till after the evidentiary hearings to file that application with DCR, similar to our approach for filing a notice of intent with the Concom, would hold true. If after these evidentiary hearings, we've heard any additional testimony.
I'm sorry, if you dropped out. If after these
evidentiary hearings, we've heard additional testimony that would cause the project team to consider some minor modifications to the project for improvements. We would want to incorporate those into that DCR filing as well as notice of intent filing and file those concurrently and run those two filings and approval processes concurrently.
Have you finished your answer?
Yes, sir.
Okay. In the company's petition to the Siting Board on page 2, and you don't have to look at it unless you need to after I ask you the question. On page 2 of the petition, the company represents that there are no Mass DEP Zone 1 or 2 wellhead protection areas on site, and that there are no certified or potential vernal pools. Do you recall that? This is to the panel now again, not specifically to any witness.
This is Mark Bergeron. Yes, I see that reference. I do.
Taking the second issue first, vernal pools. Not only did the company represent there are no certified vernal pools on site, it also represented that there were no, quote, potential, close quote, vernal pools. Is that correct?
That's correct.
That representation was false, correct?
That representation was true. At the time of the filing in April of 2025, there were no known or mapped certified or potential vernal pools on the project site. That was a true statement at the time of filing.
Well, what was the basis for that representation?
A review of Massachusetts GIS data layers, an inquiry to Massachusetts Natural Heritage and Endangered Species Program as part of our due diligence for this project indicated that there, again, were no mapped state listed habitats, certified vernal pools, or potential vernal pools on the project site.
Was a site visit conducted prior to the petition being filed with the siting board?
Yes, and I mean, I believe we're getting into some wetlands issues. I'm happy to answer this question, but yes, Epsilon Associates delineated the wetland resource areas on the project site in 2024.
So that would include you, sir?
No, that would include members of my company.
And are the members of the Epsilon team that conducted a site visit to determine resource areas, are they competent in identifying a vernal pool?
Yes, the senior scientist who is responsible for the wetland delineation on this project site has over 20 years of experience delineating wetlands and identifying vernal pool habitat.
So how is it that they missed that there were actually not potential vernal pools, there were actual vernal pools on site that subsequently got certified by the state when it was raised to the state's attention by the town? How did they miss that?
Sure. The project site, as indicated in our petition, is an old auto salvage facility. Many of the wetland features are remnants from removal of those features. And so when we delineated our wetlands in late March, and I believe November, what we try to do is when we're outside of the amphibian breeding season, is we try to take a look at where there could be potentially areas that could hold enough water, that have suitable habitat around them, that appear like they need additional investigation. When our wetland scientists were on this project site, many of the areas, actually 2 out of the 3 areas that have since been certified by a third party, are what I would describe old tire ruts.
I'm sorry, what I would describe what?
Old tire ruts. So they're very shallow depressions.
Forgive me, I'm sorry, I just can't hear you, or what I would describe what?
As old tire ruts. I'm sorry,
Thank you,
I don't
thank you.
usually have a problem with not being able to be heard. I don't know if it's my
Thank you.
position to the microphones today. And so, I would say that it was not their opinion that they would hold enough water. And I will say that I'm not contesting that these areas have been certified. But if you want to talk about this now, we can, but certainly in the certification process and how these areas were certified, there is no evidence that these pools actually complete the appropriate hydro period to support a breeding amphibian habitat population. So again, disturbed sites that have shallow areas, ponding, that's something that if you're there outside of the breeding season, you may not pick that up.
So are you saying that the company contests that there are that you contest the validity of the state certifications of the vernal pools on site?
I am not, sir. I am just merely trying to explain to you how a wetland scientist on a project site of this type may have overlooked the fact that certain areas would have egg masses in them. So again, we were not there during the times of year where that evidence would be there. We do typically look for that evidence, but I am not contesting the fact that the state has certified these as vernal pools. And in fact, we do recognize that and have modified the project design to comply with all performance standards core vernal pool habitat in the Commonwealth of Massachusetts.
Was there a conversation about the fact that the petition represented that there were no potential vernal pools on site and the subsequent certification of vernal pools? Was there any internal discussion about that fact?
Well, yes, I mean, when we realized or when we learned that there were three.
Let's break it down. Let's break it down.
Well,
I want to know.
You didn't let me answer my question.
No,
You asked the question that I wanted to answer.
No, but your answer is just speculation and sort of hearsay. So I want to break it down. Why don't you describe, Mr. Bergeron, every conversation that you had relating to the representation in the petition that there were no potential vernal pools on site after it was later certified by the state that there actually were certified vernal pools on site? Why don't you describe every conversation you had with your internal project team about that issue?
We just worked with the client to take this new information and to redesign the project around those areas.
I want to know conversations that you personally had with anybody from the Epsilon project team about missing the vernal pools on site. Did you have any such conversation with them?
Well, certainly we've revisited the site to take a look at those areas for ourselves, as we've revisited the site to take a look at our delineation as this information has come up. We've looked at a lessons learned on this as far as, if we're there and it's not during the breeding season, these areas should have been flagged or should be flagged in the future so this doesn't happen again on any other project site. And we did a lessons learned debrief, and then we moved on and they were certified. So we worked with the project proponent to adjust the design to comply with all the applicable standards that we needed to consider.
And who were the specific people involved in that lessons learned debriefing? There was you and who else? Who did the site visit?
In particular, I've been relying on our senior wetland scientist on the project, Mr. Greg Hochmuth. That's Greg, G-R-E-G, Hochmuth, H-O-C-H-M-U-T-H.
And has he been directed to have any further training in recognizing potential vernal pools as a result of this lesson learned?
He has 20 years of experience doing this, and I believe, again, it's a lesson learned for him. And again, it's a lesson learned. He has experience, and he will identify potential vernal pools for additional consideration in the future on sites. Any marginal area, I'm sure that if he could go back in the time machine, we may have taken another look at those areas during the breeding season more closely.
Okay, so then
Excuse me, can I just have one moment, please? We have one moment here to confer.
No, you can't confer off the record. You can confer by talking.
I would like to say something.
I believe that they can confer. As a matter of fact, yesterday you pointed out that you didn't mind if the panel conferred as long as they didn't talk to me. So,
yeah, but not with a question pending.
You're saying, Mr. Pucci, that you're objecting to the panelists conferring with each other while a question is pending. Is that right?
Yes, unless we can hear it. I mean, they're free to offer clarifications on answers, but they can't shut the microphone off while I have a question pending.
Your response,
as they're doing
Mr.
now.
Kaplan?
I don't believe there's a question pending. I believe I responded to your questions, and I don't have anything further to add at this time.
Okay, so why don't you tell us what you discussed with Mr. Benito while you were muted?
Sure. Mr. Benito asked if I should also add some more details to identify that we did identify these seasonal depressions that have now been certified as vernal pools. Actually, we identified one of the seasonal depressions that is now certified as a vernal pool. and that we did do an engineering, or ARUP, the ARUP, the project's engineer or the company's engineer evaluated those areas to see if they qualified as isolated land subject to flooding under the Wetland Protection Act. And he thought that that would have been an important thing to add to the record.
Yeah, so adding that to the record, so that you're describing what would be potentially a vernal pool, right? But the company represented there were no potential vernal pools on site, right?
Based upon mapping provided by the state, and based upon our investigations looking at these areas, they're very shallow. Again, as indicated on the certification forms, and we can dig into that if you want, they're less than 2 feet in depth. So typically small seasonal depressions like the one we're talking about here don't tend to hold enough water during the course of the breeding season and the subsequent time necessary for any of the amphibians to metamorphose into adults and then leave the pools. We had seen these same areas dry during portions of the breeding season in previous years, such as in 2024. So just those facts alone, when you put them together, professional judgment would say that these areas do not likely consistently support breeding amphibian populations such that they would necessitate being certified.
On the issue of protection of water quality for drinking water supplies, the proposed project is located within Zone A and Zone C water protection areas for the Ware River watershed. Is that correct?
That's correct.
And this is part of the public water supply managed by MWRA?
Yes.
Is it regulated through Mass DEP?
The actual water supply protection area is not regulated by Mass DEP. The wetlands that are within that resource are regulated.
By Mass DEP or Conservation Commission or both?
Are you asking me if the surface water supply zones A and C are jurisdictional by Mass DEP?
Yes.
Or the Conservation Commission? I believe I provided a response to that. No, Mass DEP is not the issuing authority for proposed actions within the surface water supply protection areas, Zone A and C. That would be the Massachusetts Department of Conservation and Recreation.
Thank you for that clarification. Why do zones, and again, these are questions with regard to site selection. We're not getting into the wetlands issues now. Why, as a general matter, from a site selection perspective, why do zones A and C to a public water supply matter?
Because they are within the watershed that drains to a public water supply.
And Zone A is the zone closest to the surface water bodies, correct?
That's correct.
And they provide strictest protection, correct?
There's a higher degree of protection for Zones A than Zone C, yes.
Do you agree that there is a strong presumption against industrial activity in the Zone A?
There are a lot of different uses allowed in Zones A and Zone C, and that is why the Massachusetts Department of Conservation and Recreation has the Water Supply Protection Act to review that. So there are all sorts of uses that can be put into these areas as long as they're designed with the appropriate standards and then reviewed subsequently by the Massachusetts Department of Conservation and Recreation.
Do you disagree with my question or statement, actually, let's call it that there's actually a presumption against industrial activity in a Zone A?
Can you show me the citation in the Watershed
Just
Protection
asking,
Act that provides
correct
that?
me.
I'm sorry, I didn't hear that. I didn't hear what the witness said. Can you show me the citation in the watershed?
No, I want you to correct me based on your knowledge of the applicable regulations. I'm asking you, isn't there a strong presumption against industrial activity in a zone A?
I neither agree or disagree with your presumption. That's your presumption.
I know it's my presumption. Tell me if you disagree with it. Tell me if it's wrong.
Well, I just answered your question previously to indicate that there are all sorts of uses that can be constructed within a zone A or a zone C watershed protection area.
I understood your answer. And what I'm asking is, isn't there a presumption against industrial activity?
Again, can you show me where in the regulations that presumption exists? You're asking me for a specific presumption in the regulations.
No, we'll move on if you can't answer it. The zone C is the broader watershed area, correct?
Could you define broader? What do you mean by broader?
It's not in direct proximity as the zone A, correct?
That's correct.
All right. And development is allowed in that zone, but only with strict controls, correct?
There are standards associated with development in those areas.
Stormwater control and contaminant protection are required in those zones, correct?
Yeah, compliance with the Massachusetts stormwater standards is a requirement for proposed activities in those areas.
Did the company assess water contamination issues in the event of firefighting at the site, if a firefighting event is needed?
How does this question relate to site selection? I mean, I can't actually answer that particular question.
Maybe Mr. Benito can.
Could you repeat the question?
Yes. Did the company assess water contamination issues in the event of a firefighting event at the site?
I don't have my stormwater expert on the panel today because I was under the impression we were not going to be discussing stormwater needs. So I cannot answer that question without having my appropriate professional engineer, subject matter expert under the Massachusetts stormwater guidelines.
Okay. Was modeling for surface water runoff during firefighting conducted?
Again, I have not talked about, I was not prepared today to discuss stormwater. These questions will be most appropriately handled by my fire safety expert and my stormwater design team.
This is Mr. Bergeron, though, Mr. Pucci. I'd like to just add that, the project has been designed to comply with all of the Massachusetts stormwater.
I'm sorry, the project had been designed what?
To comply with all of the applicable Massachusetts stormwater management standards as outlined in the petition and as the stormwater expert can attest to when you have him on the panel.
Yeah, my questions go to site selection. They're not calling for particular expertise. So if somebody can answer the questions, that's fine. If we have to defer it, that's fine too.
If you could, Mr. Pucci, if you could, in asking those questions, clarify their pertinence to site selection, that would be useful.
Yes. With regard to site selection, one of the big issues is the appropriateness of the selection for a 180 megawatt facility, basically a large scale utility project in the zone A and zone C to a water protection area. So it has to do with the soundness of the site selection. That is it. And I understand we're not gonna, it's not a silver bullet. We're not gonna knock out the project based on only stormwater management issues, but there are certainly relevant questions with regard to the appropriateness of, when all things are considered, whether it was an appropriate site selection at the Oakham site in question. That's the reason for my questions of why it goes within site selection.
Understood. If I may, just real quick. So I'm just asking, when you ask those questions, to direct the witness specifically to the site selection process, because your question was much more general in terms of the evaluation. Thank you.
Sure.
I think Mr. Benito started to respond.
I have nothing. I apologize. Thank you, presiding officer.
You're finished? I'm sorry.
I'm waiting further question.
Okay. All right. Let's see. I'm going to look at my notes just to I'm not going to go through the process of asking you 20 questions and getting the same answer that it has to go to the stormwater engineer. So just give me a moment to move ahead here.
While you're
Well,
thinking about that, Mr. Pucci,
actually, some of these I do actually have to ask. So if we need to take a break, we can do that. And I'll try my best not to ask questions that will receive the same answer, but some of these questions have to do with site selection, so I do have to ask them.
I would like us to plan on winding down in the next 5 minutes to take a break, which will be a lunch break. And if you would like to ask additional questions before we take that break, that's fine.
Yeah, I think I can complete this line, hopefully. What did the company do soil testing to determine infiltration rates on site?
Infiltration rates.
Sorry, again, can you confine it whether you're talking about site selection or not?
Yes, on site selection. Did you do soil testing in connection with the site selection decision?
No.
So you don't know what the soil permeability rate is before you selected this site?
I do not know what we did not know what the soil permeability rate was prior to selecting this site.
Prior to selection of the site, did you quantify the increase in impervious area that you were proposing?
I didn't. We could not have calculated that at the time of site selection due to the fact that during the site selection, we are generally looking for appropriately sized parcels. In a very general manner, we have not at that time of the development process brought on a professional engineer firm that would be able to do those calculations you just referenced.
Had recharge volume reduction been modeled prior to site selection?
That is not something I'm aware of being conducted on this project or other projects I've worked on.
What is recharge? Do you know in connection with the water protection zone?
I do not have the definition of what recharge is in connection to the water protection zone.
How about preservation of natural infiltration? Do you have any plans on how the company intends to preserve natural infiltration?
In the site selection process?
Yes.
We did not evaluate that during the site selection process.
And it's fair to say that you also did not do any site-specific infiltration testing as part of the site selection process?
That is fair to say. The site selection process and all of these questions you're asking us would require site control, which as part of the site selection process is not something that we have had, that we or anybody typically has.
And now 2 questions, and we can't take the break. This is good timing, Mr. Presiding Officer. I just have 2 final questions on this subject matter. Why did the company conclude that a water protection zone was an appropriate site for your large-scale standalone BESS facility?
As Mr. Bergeron previously testified, many activities can be cited and permitted within the zone protection areas, so long as the appropriate BMPs, controls, and permits and reviews have been put in place.
Okay, and that covers oh, sorry, go ahead.
That's it. Thank you, sir.
Yeah, that covered my second question. So I'm done with this line of questioning, Mr. Presiding Officer. So if we wanted to take a break now, or I can move on.
And by this line of questioning, could you clarify what you mean by that?
Stormwater management issues and related due diligence with regard to site selection.
Understood. Yes, we will move towards taking a break. I do want to clarify an issue that arose 15 or 20 minutes ago regarding the panel of witnesses consulting with each other. In general, it's reasonable that they not have the opportunity to consult with their attorney while the question is pending. But in general, I find it reasonable for them to consult with each other off mic. I find that to be an efficient way for them to provide accurate information in response to your questions. If there's an unusual situation that you think requires them not to consult with each other, please raise it at that time. I'll also just make one other comment. If it comes up, there are two sets of information requests that the non-town interveners issued. They both start at INT-1. So if we are referencing those information requests as exhibits, I would ask people to specify whether it's part of the first set of information requests or the second. With that, we will take a break for lunch. We'll break for an hour. We will resume at 1 o'clock.
Thank you.
And thank you. Off the record.
Daniel,
Hey, Daniel? I don't know if you guys.
For a second.
I don't know if you guys can hear. I mean, I was just wondering if anybody had any more questions for Mr. Callahan for today. Otherwise, he doesn't have to sit here and can go back.
Am I unmuted? Can you give me 30 seconds, please,
Oh, of
Mr.
course.
Kaplan? And I'll be right back with you. Can you? Joe?
Andy,
Yes.
I was just double checking you can hear me. Then I've got my technical issues fixed. Apparently I do. Thank you.
Okay. You hear us any better?
No.
Good. I just wanted to make sure.
Okay, no.
We're still working on that.
So I believe sorry. Ooh. Mr. Kaplan, you were asking whether anyone had questions for Mr. Callahan, right? Sound questions for Mr. Callahan?
I understand there's going to be more, but I just want to know for the rest of today.
Yes, Mr. Pucci, do you have any questions for Mr. Callahan?
I had a follow-up from what was asked from the sighting board earlier, but not until later, and I bet I would not get to it. And I can also subsume that into my other cross-examination on the sound issues. So I'm happy to have him leave as long as he's coming back next week, as we had talked about earlier.
Yep, he's definitely coming back.
Does that work for you? Does that work for you, Mr. Presiding Officer? Because it does for me.
It does work. It does work for me. So,
Okay.
Mr. Reich,
Yes.
you're okay with that as well?
Well, I will have to have Mr. Ferry here I'm not prepared to do the sound cross he was. So, as I said, he gets back the week of the 16th. So if we could have and it could be that Mr. Pucci will cover everything that Mr. Ferry might have covered, because Mr. Ferry was going to follow him in any case. But I do want to give him the opportunity to have that cross-examination.
Okay, so, and I just want to make sure the Salpes aren't there. If they have any objection, now would be the time to speak up. Mr. Kaplan, so that's fine. You may excuse.
Hey, right, you're off the hook.
Your witness. All right, couple procedural matters.
Are we on the record?
We don't mean on the record, yes. So Attorney Kaplan, I received your updated draft exhibit list. Thank you. A couple small modifications. I think the way that you designated the exhibits that were discussed during day one is fine, but I want to make it clear on the record the designation that you used. I had referred to the exhibits as RPI-1, I believe, and RPI-2. But you listed them as INT-HE-1. I didn't actually see the second one. INT.
So, yeah. I need to check that. Didn't actually write the list.
Oh, no problem. Just update it.
Okay.
Please.
Can somebody tell me where you're talking about? I do have it. Or does that
You're
matter?
talking about on the draft exhibit list?
Yeah, what you were just asking about. I just don't know what you're referring
Yes.
to.
So it's on page 64,
Okay.
and it's the first interveners exhibit.
Okay. I'm there.
And-
Yep.
And the first one is INT-HE-1,
Okay.
which references RPI-1 that we referenced yesterday.
Yes.
So
Is that
I'm
being-
mostly just pointing out that it's using a different exhibit designation from what we used.
Yeah. What did we
during the
use
hearing.
again? What did we use again? I was just going to update this.
I believe we used RPI-1.
Okay. So it would be INT-RPI-1.
I think just
No.
RPI-1.
RPI-1.
Well, no, okay, that's what it was. Yes, that's what it was on day one, but I'm proposing that we just go with the designation that company used in its draft exhibit list.
Oh, great. Okay.
So that would be HO-1 and HO-2 for those two exhibits?
So the correct designation will be INT-HE-1 and INT-HE-2.
Was it HE or HO? I'm sorry.
It's HE standing for hearing exhibit, I assume.
Okay.
And that's the drone aerial.
Actually, so INT-HE-1 is the New England market stats, ISO New England market stats.
Yep.
And then INT-HE-2 was the Tingsboro application.
Okay.
Okay. And
So do we need to update or?
actually,
I'm just
Mr.
confused.
Kaplan,
Yes.
you don't need to update.
Okay.
As drafted, it's correct. I just needed to update the record so that the reference was clarified for the exhibits that were discussed just day one.
Thank you very much.
Yeah,
And
and
then-
it actually does need to update because we need to add the HE2 because that's not on there.
Well,
Which
so it's farther down, Mr. Pucci, which my
okay.
colleague just brought to my attention.
Okay, sorry. Oh, there it is.
It might be slightly less confusing if they're put together, Mr. Kaplan.
Good. I see it.
Mr. Hearing Officer, before Mr. Pucci begins, could I just check on a procedural issue, which was there were two documents that were sought by both the town and by the interveners regarding separate agreement, well, an agreement and then an amended agreement. The first agreement was back in 2022. The amended agreement, sorry, was in November of 24. We never received those agreements. The company claimed that they were irrelevant. But then the company actually filed I guess what is a final agreement slash option agreement with the site owner, and that was filed in January of this year. And those two agreements that I just mentioned are listed in that document. And when Mr. Ferry, sorry, asked about those two documents, they were not produced, and the witness, for whatever reasons, said he didn't have them or wouldn't produce them. I don't understand why they weren't produced in the first place, and now that they've been the subject of cross-examination by Mr. Ferry regarding the final agreement signed in 2026, I further don't understand why agreements mentioned in that very document, which is now an exhibit, have not been produced. And those are certainly relevant to, they were relevant to Mr. Ferry's cross, which couldn't be completed because he didn't have the exhibits. And I assume that Mr. Pucci would also like to see those exhibits so that he could cross on those.
So, Mr. Reich, could you specify the exhibit
Yeah.
that was introduced and the exhibit, the exhibit name for that?
I can give you the exhibit name. I'm not sure I have that I took down the exhibit number, but it's memorandum of option. And it's got Pierce Atwood LLP at the top of the page. And it's called a memorandum of option to purchase agreement. And it's dated January 16th, 2026 between Maracas Storage LLC and Zovl, ZOVL Properties LLC.
I do have the number. I was going to ask about it today, if you want it.
Yes, please.
It's Oak-20 paren 1 close paren.
Well, Mr. Reich, I don't know why it's not coming up, but yeah, I'm not planning to order them to produce the documents that were referred to in Oak-20, open parenthesis 1. And it would, that was a subject of the motion to compel from the town, and it remains under advisement. But for purposes of the testimony that's happening today, I'm not going to order its production before the testimony takes place.
So do you expect to issue your ruling before we close the examination of this panel?
I'm not sure when it will be issued, the ruling, but if it becomes, if it obstructs the ability of counsel to get the information to which they're entitled, then I will make a decision on it. But at this point, I don't believe it does.
Well,
go ahead.
I might respond. Those two, the agreement and the amended agreement, dated respectively 2022 and 2024, are very material to this proceeding. For one reason, that as I don't know who was either Mr. Bergeron or Mr. Benito described today, the company did not do certain testing at the site at some point, and they said they needed to get control of the site. I don't know when when they went to the site and didn't conduct some testing, but they did say they went to the site, they looked it over. They didn't do certain testing. But if in fact they controlled the site, that contradicts, that may contradict what's in the record. So it was relevant to us to see what kind of an agreement was reached in between what parties and when, since the company has taken the position that when they had control of the property, the bylaw of the town and the approval of the Attorney General had not yet taken place. And my understanding of the law is that once the bylaw was approved by the Attorney General, then the effective date of the bylaw becomes the date that the bylaw was passed by the town. And that was much before the first agreement referenced in the it's contained in this memorandum of option. So it goes directly to an issue that's relevant here, which is, did the company have control, did it not have control when it essentially ignored the bylaw of the town, or thought that there was no bylaw that was going to control their investigation and so forth. And for the other reason that it goes to what testing could they have done if they actually had control of the property? They could have done certain testing. So
yeah, I just wanted to add to that, Mr. Presiding Officer.
Go ahead.
I could. Yeah, I agree with Attorney Reich on that issue. I would add further, the standard for discovery is not necessarily whether it's admissible or relevant. It's whether it's reasonably likely to lead to discovery of admissible evidence. And, you know, there are multiple reasons why those documents are relevant. First of all, how can you possibly examine public interest and financial viability of the project if you don't know what the purchase price of the land is by this investor entity that's seeking the permitting? There also might be relevant provisions in those purchase and sale agreements concerning the condition of the property, you know, the environmental condition. Are there contingencies in there for if it becomes a brownfield site or if something is revealed? Have representations been made in there by the owner to the purchaser? Issues like that. Clearly, we're entitled to look at that in the context of these proceedings. I don't have a lot of questions, you know, that would result from that, but I definitely have questions that may be related to that for this proceeding. And, you know, my purpose is never to bring back a witness unnecessarily. So if we can cover things with Mr. Benito while he's here, you know, I'm fine to just seek to do that now as opposed to waiting for a ruling and then having to bring him back at a later time. But respectfully, and I know you haven't had a chance to really review the legal issues, but I can't imagine how the siting board could possibly uphold the objection to not producing those purchase and sale agreements. They're clearly discoverable in this matter. So thank you for hearing me on that.
Thank you. That is the first time that I've heard some of those arguments, you know, regarding the condition of the property. I don't believe those were advanced in your motion, and I'm not sure exactly how to handle that. But I will just note that it's not arguments that have been presented before. Attorney Kaplan, did you start to speak?
I was just going to mention that I believe that the law only requires that you ensure site control. The price that the company has paid is certainly not relevant to whether or not they should get a zoning exemption. So if attorneys for the interveners and for the town want to ask questions about what's in those documents, having nothing to do with price, I suppose Mr. Pucci or Mr. Ferry or Mr. Reich can ask those questions, and we will answer them.
Well, respectfully,
but the actual documents have nothing to do with whether or not a 48 zoning exemption is going to be granted by the EFSB.
May I respond?
You may.
So I don't see how it's useful for us to try to cross-examine a witness about a document that won't be produced. I mean, if we're not, whether or not price is an issue in this hearing, I'm not prepared to respond to that at this point, but certainly the contents, the subject matter, whether there was for instance, a requirement that there be a site assessment done before title transferred, or, you know, any of the numerous questions that you might have about a piece of property that's then going to be developed later. Further, it is of record that the same owner that has now signed this option agreement to transfer the property to Moraga is the same individual that came before, same company that came before the planning board back in 2024, I believe, or maybe even a little bit earlier, 2022.
I'm sorry, I didn't hear you. 2000 what?
2000, I think more like 2022 was the first time, and then 2024 again came looking for a permit from the planning board to develop the site as a non-invasive, non-polluting online auction facility where a bunch of damaged cars would be parked. And it was represented there would be no taking apart of the cars, no oil dripping, you know, nothing would go on that would harm the land. And 2 consecutive permits were granted. They were never, no one ever did anything at the site, and the second permit ran out before this proceeding, and shortly after that permit ran out for a auction facility, Moraga entered the picture and petitioned to first had a hearing and then petitioned to put in the petition that's at issue here. So their control of the site or lack of control of the site and when, plus the conditions under which they obtained control is all very relevant to this proceeding. And the testimony today was, I may get this wrong, but they said until they had site control, they couldn't go on and do site testing. So when did they get site control?
I think the memorandum shows that site control came on November 12th, 2022. And any argument about what should or shouldn't have been done certainly could be from the, in brief. Or you can ask whatever questions you want, but.
Again, Mr. Kaplan, it's not sufficient to say I can ask questions of a document that's not in front of me. Then I would have.
I understand. So then if the purpose of the document is to show the date of site control, and you want to argue that they should have made testing, soil testing, or whatever else when they had site control, the date of the site control is November 12th, 2022. That's in the document. So anything else, you can argue. But in terms of what's before the EFSB, site control happened on November 12th, 2022, per the document that was provided by the company.
And how is it not relevant that date, that a document that's referenced there in which site control took place, why is it not relevant to look at that document to see all the aspects that we've already discussed?
Yeah, I should note, Mr. Presiding Officer, too, you'll remember when I filed a motion to compel, it was on their initial response. I forget how many responses I alleged were inadequate. And I basically tried to have as streamlined of a document as I could to get before you. As we get ready, for the trial, I'm happy to supplement a supporting memorandum of why those should be produced. And if I didn't include every argument about why they're clearly discoverable in this case, I apologize for that. But it was, again, for the purpose of kind of putting the issues before the citing board, hoping to get a ruling on it all before we went forward with the evidentiary hearing. And I've been willing to compromise on behalf of my client to say, look, I'll deal with the responses as they are on cross-examination. I'll probe further and see why certain information wasn't provided, but not with respect to such a critical document. So I renew the request. We can always bring them back if you rule later and we get those documents. But again, bringing them back on a certain day for, no more than 20 minutes of questions on what may or may not be in there doesn't seem like a really great use of time. But mainly I just want to get that back before you, that we are definitely still seeking those documents. And again, I can't imagine a basis for not producing them.
Mr. Benito is here for the duration. So, and if people want to ask him questions today,
all right. So I'm not going to rule right now about the documents. I will say that I was not persuaded by the initial motion to compel. I'm not sure the extent to which I will consider additional bases for the documents, and I did. So I'll just say that for now. Also, some of these issues, having to do with whether the company violated the bylaw, more clarity will arise once we have the letter from the AGO's office that was approving the bylaw. If that gets admitted into evidence, it's not yet clear on the record whether or not the proposal was in violation of the bylaw or not. So I can revisit these issues after that the approval from the AGO's office has come into evidence, if somebody is planning to introduce that, and if not, I will discuss the introduction of that document at that time.
And Mr. Keller, we're certainly not trying to press you with everything else you're trying to do to get a swift decision in this. I understand you've got 1,000 things to deal with, but the reason certainly that interveners did not specifically reference the site investigation as part of the reason for getting these documents is because, to my mind, that the first time I heard that the company could not do certain tests at the site based on their lack of control was today, when both Mr. Benito and Mr. Callahan, I think it was, no, not Callahan, sorry,
Bergeron?
Bergeron, yes, sorry. When they testified that, they didn't have site control, so they couldn't go around doing testing and all those kind of things that they might do to determine the viability of a particular site. So that, to my mind, that was new information. If I missed that in the record, I'm glad to be contradicted. But so that's new information we didn't have when we filed our motion to compel. We filed a motion to compel simply on the grounds that these were relevant documents. It's relevant, at least the company thinks it's relevant, that they have an option agreement in effect now as of 2026. If they thought it's relevant now, it should have been relevant back in 2022 when they presumably had their first option agreement. So, but anyway, the issues about site access for purposes of testing did not come up previously.
Okay, well, I'll just mention right now, without making a decision on it, that I'm not persuaded at the moment that it makes any difference whether it was within the company's control or not to conduct this site testing. And perhaps you could ask additional, or Mr. Pucci could ask additional questions about that. I mean, the fact is they testified that they didn't conduct certain tests prior to making their site selection. So whether they could have or they couldn't have, they didn't. So I think that's probably what matters here. And the reason for their inability to, I don't know that that's relevant.
All right, well, hopefully we'll have a chance to discuss that further after the cross.
Okay.
And
One
I mean,
small-
yeah, so do you want me to introduce the AG letter? I have no problem doing that if you want it. But...
Yes, Mr. I would like you to.
Okay.
One other housekeeping item. I referenced the exhibits arising from the non-town interveners information requests, and the format that I would like to use going forward. And Mr. Kaplan, you can amend the draft exhibit in this regard, is to call the responses to the first set of information requests INT-1-1, INT-1-2, etc., where the middle number indicates which set of information requests we are talking about.
I will do that. Thank you.
Thank you. And with that, Mr. Pucci, I would invite you to resume your questioning.
Okay. This is to the panel. Before we took a break, I asked a question about what the company concluded about site selection suitability from the perspective of a water quality protection zone, and that question was answered. Then I have another question about compatibility and zoning to the existing community. What is it about your large-scale power facility that is compatible with the existing community?
Are you asking me if I know or understand what the various zoning is of this town?
No, just asking for an answer to my question. What is it about your large-scale power facility that is compatible with the existing community? And if you don't think it is, you can tell me.
Yeah, the existing community is zoned residential, and this facility as proposed is not a residential facility.
So you do not, you agree that it is not compatible with the existing community?
I agree that it does not fit within the residential zoning bylaws outlined within the community.
Do you agree that this is an industrial scale use in a rural residential district?
Yes.
Do you agree this would be a precedent-setting industrialization of Oakham?
No.
Why is that?
It's my understanding there is other energy development going on or has gone on in the town of Oakham. Specifically, it's my understanding that there is other generating assets of energy in the town, specifically that being solar panels.
Of the comparable in scale to a 180 megawatt standalone BESS facility?
I do not know the scale of that development. It's not our project or something that we worked on, but I am aware of the town of Oakham having other non-conforming developments happening within the town, specifically with regard to energy development.
Is it fair to say that that's a large-scale solar facility, the other facility you're thinking of?
As previously testified, my company is a standalone battery energy development. I do not know the specific definitions of what a large-scale solar development would be compared to a solar development of some other classification.
Okay. Again, earlier we established you consider yourself knowledgeable and in fact a person that can offer expertise concerning best practices concerning appropriate siting for a standalone 180 megawatt BESS facility. Is that right?
Yes.
Now, I have a long question now, which I apologize for, but I'm going to ask you a long question. Do you agree that a BESS facilities in the range of 150 to 300 megawatts are most commonly cited in one of three scenarios as follows? 1, co-location with utility scale solar. 2, adjacent to existing substations near or in industrial corridors or edge of city zones. And 3, repurposed brownfield sites or sites containing retired fossil fuel plants.
I'm sorry. What was the question in there?
Do you agree that 150 to 300 megawatt BESS facilities are most commonly cited in one of those three scenarios?
I do not agree.
What do you disagree about that?
I believe you just asked me if standalone, if batteries are commonly co-located with solar, commonly developed on brownfield sites, or commonly developed in industrial zones, and I do not agree with that. I am not familiar with what your definition of commonly is.
Well, do you agree that most facilities of that size are located within one of those three scenarios?
Again, sir, I can only speak to this particular project. I cannot begin to speak for the entire industry as to how they or where they go about their development.
So do you disagree that that would consist of best practices locating such a facility in one of those three development patterns?
I would not, I can only speak to what we proposed here, sir, and I would say what we proposed here clearly is not what you are laying out in your question. So as such, I would have to say that I do not agree with what you're saying, because the project that we are discussing in these hearings is not in either or associated with any of those three parameters that you say are commonly done for developments of this scale.
That's right. And that's my point. That's why I'm asking you. Isn't it most commonly the case that for a large facility, 150 to 300 megawatts, you're going to typically see them in one of those three places: co-location with utility scale solar, adjacent to existing substations near or in industrial corridors or edge of city zones, or repurposed brownfield sites or sites containing retired fossil fuel plants. Isn't it a fact that most such facilities would be located in one of those three development patterns?
That is not a fact that I would say is a fact.
In determining Oakham was an appropriate siting choice, did you assess the capacity of the town's fire department?
That was not one of the, that was not, no.
Why is that? Wouldn't that be relevant?
As laid out in our petition, our site selection process involves publicly available data. That publicly available data typically consists of mass GIS data layers to associate and categorize what the likelihood of your site surveys will reveal when you obtain site control. We also, as outlined in the petition, try to minimize impact on abutters by locating the facilities to the best of our ability away from those residents and or ensuring that the facility that we are looking, or the property that we are looking at, could be mitigated to not impact those residents. Existing public roads is a pretty clear siting selection. We have to obviously access the site for construction and operations, and then minimizing environmental impacts and ecological impacts associated with what the actual footprint would likely be on the subject parcel.
So the capacity of the town's firefighting ability, size, and scope of its existing fire department was irrelevant in your site selection choice?
I did not say that, no.
All right, I misunderstood. So in determining, let me ask again then. In determining Oakham was an appropriate siting choice, did you assess the capacity of the town's fire department?
No.
I'm confused. Can you, I thought you just said that it was a relevant consideration, and now you're saying you didn't consider it. Can you help me out?
I apologize for confusing you. My question was, my answer of no was to your question, asked if we, the company, looked at the specific capabilities of each and every town that we looked for project sites in. And my answer to that remains no, we did not.
Okay, and how about when you zeroed in on Oakham? Did you assess the ability of the town's fire department to respond to emergencies there?
We did have a meeting with the fire chief in town after we had obtained site control.
And did that meeting have relevance to your site selection and proceeding with a petition for approval in this area?
As previously stated, no, it did not. We had already at that point selected the site.
And so what was the purpose of meeting with the fire chief?
Meeting with the fire chief in the town is a very important step of all development, and basically any form of land development that is out there. It's something that you need to do to ensure that you're talking to the people that have the most intimate knowledge of the town. With regard to speaking specifically to a fire chief or a fire department, the fire department as well as the police department are responsible for public safety. And it's clear that any development of this magnitude needs to be developed, constructed, and operated safely. Therefore, it's very appropriate to ensure that you are speaking to those safety experts in the town.
So firefighting and emergency response capacity is relevant to the project, but it's not relevant to your site selection process. Is that right?
I think that would be accurate.
Okay. Did you determine whether the town has a hazmat team or hazmat specific training?
I do not know the extent of the hazmat team or hazmat training. I believe in our initial discussions with the town, there may have been mention of a hazmat team. If you give me a moment. I can't recall or see where we would have actually addressed the hazmat team capabilities from the town.
Okay, but it was not a relevant consideration in making your site selection choice. Is that fair?
That's fair.
Did you determine whether the town has fixed water infrastructure before you made your site selection choice?
We did not determine that.
Now, kind of moving over to project design, although some of these questions will still bear on site selection. First, for the equipment proposed for this facility, in determining the equipment proposed for this facility and determining whether it is fit for its intended purpose, did you rely solely on manufacturer or vendor representations, or did you arrange for any independent review?
We contracted out a professional engineer and design firm that has relevant experience in similar development activities, as well as consulting with various OEMs and industry equipment providers.
So for the equipment providers, in other words, that you're relying on the provider itself, right? Like the vendor proposing equipment, you're relying on their representations?
Yes, for example, in this proceeding, we have relied heavily on Tesla's subject matter expertise with regard to how they design, engineer, manufacture, and install these battery components.
You anticipated where I'm headed next on my questioning, but before I get to that, with regard to the Tesla equipment specifically, before I get to those questions, you mentioned retaining a professional engineer to sort of serve as some type of independent reviewer to manufacturer representations. Is that correct, or is that wrong?
That's wrong.
Okay, can you describe that for me? What was
what I was referring to is the professional engineering firm to ensure that the equipment is adequately spaced, to ensure that the grade can be within the parameters outlined for the specification of the equipment, to ensure that the design and footprint of the proposed facility could accommodate the requirements specifically outlined by the original equipment manufacturers.
Okay. And is that firm Epsilon, or is that somebody different?
That firm is Arup, A-R-U-P.
A-R-U-E?
P as in Paul.
Arup, sorry, yep, okay. But no independent review or verification of manufacturer representations with regard to the Tesla equipment. Is that fair to say?
At this stage of development, that is fair to say, yes.
Okay. Now, on project design and the issue of fitness of the equipment, are you aware of incidents or accidents involving Tesla Megapack style grid scale battery systems?
Do you have an IR that you're specifically referring to, sir?
No, I'm asking you, well, your IR, you denied it. I don't recall specifically which one, but you denied, I think you said there, I think I asked, this is a long question to answer your question. I think I asked somewhere in the IRs, did you have an analysis of accidents or incidents involving these Tesla Megapacks? And I think your answer was there was no such analysis. Do you recall that?
I do not recall that. The question that I recall, if you give me a moment, I'll try to look for it.
Yep, no problem. And actually, while you're looking to refresh what you're looking at, my question was, are you aware of incidents or accidents involving Tesla Megapack style grid scale battery systems?
So these questions would be best, I believe you're referring to EFSB -S-14. I've reviewed this response as I've reviewed all 400+ responses personally. However, I am not responsible nor the identified witness for this particular line of questioning.
Well, I mean, it's just one question at this point, not a line of questioning. I'm asking you or the panel here today, are you aware of incidents or accidents involving Tesla Megapack style grid scale battery systems?
I'm aware of Tesla Megapack as a whole, catch-all, which I believe is what you're getting at, not the specific model that we have put forward in our petition. But I think if I understand correctly, you're asking me if I'm aware of all Megapacks that have been produced by Tesla if there is a fire or some sort of accident associated with those. I can say yes, I am aware of those. However, what I believe you also asked was with regard to the specific batteries that we're proposing in this petition, the Tesla Megapack 2 XL. I am not aware of any safety or fires related to this particular revision, if you will, of the Megapack platform.
Yes, you're very good at reading my mind. I'm going to get to that later. We can break it down a little bit. I have questions about that. In terms of knowledge of other incidents involving, again, not the 2XL, but are you aware of an incident in Boulder Combe, Australia in 2023?
As identified in EFSB 25-0. As identified in attachment EFSB-S-14(1), I am aware of that project being listed in response to that IR.
Are you aware that a Tesla Megapack in a grid BESS caught fire during commissioning in that incident in Boulder Combe, Australia?
According to the attachment in front of me, I do not see where it said that fire began in the commissioning phase of the project.
Yeah, and I'm asking for your personal knowledge today about project design and also project design as related to this site selection. So if you need to refer to something, you can, but I'm not asking you to refer to anything as I'm asking you the questions. Again, if you need to refer to it, go ahead and do it, but I'm not asking you to. Are you aware that Boulder Combe, Australia incident involved faulty components that needed replacement and that became known only after the unit caught fire?
I am not aware.
Are you aware in that incident that authorities directed nearby residents that they had to stay indoors due to hazardous smoke released in that incident?
I am not aware of this particular battery incident you're referring to in Queensland, Australia.
Do you have knowledge of an incident involving a Tesla Megapack at the Victoria Big Battery Project in Australia in 2021?
I am as aware of that as identified in attachment previously noted, yes.
And is it true that a coolant leak inside a Megapack led to short circuiting and thermal runaway in that incident?
It does identify that in this attachment, yes. I am now aware of that, yes.
And that 2 units were destroyed in that incident?
It does identify 2 Megapack units under the column units involved.
Are you aware of an incident in the US in Boulder City, Nevada, at the town site solar and storage facility near Las Vegas in September 2025?
I am aware of that.
September of 2025 was just this last September, correct?
That is accurate.
And are you aware that 2 Tesla Megapacks ignited in that incident?
I am not aware of that. As identified in this attachment, the project or that particular reference there in town site solar plus storage and Boulder City.
I'm sorry, I can't understand you, that particular reference there.
That particular reference to that project in Boulder City, Nevada is currently under investigation. I do not have knowledge of that investigation.
Are you aware that fire crews were able to contain the blaze only after several hours of burning and smoldering?
I see identified under the fire duration column in the set attachment that it was a 6 to 8 hour fire duration.
Is it fair to say that this incident highlights the difficulty of extinguishing a lithium ion fire?
I don't believe that it's fair to say that.
Okay. Do you think it's unfair?
I think that I would have to know what you are. Yeah, I think that would be, my understanding is that that is an unfair characterization.
Are you aware of an incident in September 2022 when a Tesla Megapack in a BESS facility caught fire at the Elkhorn battery facility at Moss Landing in California?
I am aware of that.
Do you know any particulars about that?
Yes, I do.
Do you, for instance, the size of the fire department, how the fire was extinguished, whether there were injuries, property damage, or environmental damage?
I have some knowledge of those particular parameters, yes.
And it in fact did involve property damage and environmental damage, is that correct?
That is not my understanding.
Why don't you tell us your understanding of what the consequences of that fire were?
My understanding from the material that I've read from the federal, state governments, as well as third-party investigators in publicly available data, state that there were no environmental impacts associated with that fire.
And earlier you testified you did reach out to the Oakham fire chief in advance of these evidentiary proceedings. So actually, that's a poor question. Let me start again. You told me that you met with the Oakham fire chief at some point in time, right?
Yes.
About the project specifically?
Yes.
All right. And that was not in connection with the site selection choice, but because of just a customary practice you would undertake once you've made a site selection? Is that fair to say?
That's fair to say.
Is it also because you are well aware that your proposal poses known fire safety hazard risks and concerns?
No.
Do you agree that when the fire chief inquired as to your company's intended fire protection strategy, the response was you, quote, let it burn, close quote?
I am familiar with that response.
And do you agree it is reasonable for the fire chief to be concerned about this so-called strategy at this project site, which abuts hundreds of acres of trees and dry wooded areas?
I do not.
Are you aware of wildfires in the New England region, including Massachusetts, over the past several years?
I'm aware of wildfires, yes.
Including even in the Blue Hills, there was a wildfire, correct? Last couple of years?
I am not familiar with the location of Blue Hills or that fire.
But areas in New England that one would typically not associate with wildfires. Is that fair to say?
Are you asking me if wildfires happen in New England?
Yes.
It's my understanding that wildfires happen in New England.
And they've occurred over the last couple of years in areas where wildfires had never occurred before. Is that fair to say?
I do not have any knowledge of that.
Do you agree that the main fire safety concern with regard to the BESS facility proposed involves thermal runaway phenomena?
I am aware of thermal runaway.
And that's where a fault such as a coolant leak, electrical short, or overheating initiates a rapid release of heat from battery cells that causes a fire. Is that right?
I cannot say that that's right. It seems that that's a definition that you read from somewhere. I do not have that definition in front of me.
Yeah, I read it from my notes. I'm asking you to correct me if that's not right.
It's my understanding that a thermal runaway can be created by water, as you indicated in your question to me, yes.
How about coolant leak? Can that cause it?
It is my understanding that a coolant leak can indeed cause a thermal runaway event.
An electrical short?
Would seem reasonable that an electrical short could as well. I believe in our exhibit here, we mentioned that. Yes.
And the now with regard to the Megapack 2XL unit, and by the way, am I pronouncing that right, or is it like Roman numerals? What is the equipment?
You're pronouncing it as it is generally characterized, yes.
Great. Megapack 2XL. The incidents that I referenced to you did not involve Megapack 2XL specifically, correct?
That is my understanding, yes, correct.
Isn't it a fact, though, that both the earlier and the latest Megapack designs have similar internal components and safety architecture?
I cannot answer that question. I'm not, no, I do not know the answer to that question.
Please tell us specifically what newly improved components are designed to prevent the examples discussed, and what specifically about their design enables them to do that.
I do not know the exact, I do not know the answer to your question.
Just a second, please. I have a technical issue. I just need 1 minute, please. Thanks.
That's fine. Take your time, Mr. Brock.
Sorry, just a minute.
While we're off, I would note, perhaps in the interest of time, these questions are all better suited to speak with Chief Morris, who's our fire safety expert, who actually would know the answer to all these questions. But Mr. Bucci can ask, obviously, Mr. Benito. But if we're trying to make this a little bit more efficient, we might want to wait for Chief Morris. I can't remember what day is he here, Brad.
This goes to project design. Well, we're waiting for the stenographer.
Sorry, I'm ready. Thanks.
Mr. Brock, I'm sorry. Did you get my last question and answer? I just want to make sure.
Yes, I did. The last, they are.
Okay. Some people don't think my questions are relevant, but I find them very relevant. So I just wanted to make sure you got it. Thank you.
Okay.
Sir, or panel, do you agree that Megapack 2XL units have not been around long enough yet, so that a likely explanation for no reported incidents is that they just haven't been in use long enough yet? Is that fair to say?
I do not believe that's fair to say.
You do not?
Correct. I do not believe that's fair to say.
How long have they been in operation?
I do not have that information.
Okay. Do you know of a single project that has a Tesla Megapack 2XL unit that's been under operation for any appreciable amount of time?
I do not know.
And I know that your project is not residential, but are you aware that Tesla's Powerwall home storage units have recently been subject to a massive U.S. recall over the risk of fire and overheating?
I am not aware of that recall.
And back to Megapack, do you agree that the one thing all the Megapack fires that I mentioned to you and that you acknowledged have in common is that they have involved lithium-ion battery thermal runaway?
I cannot answer that in the affirmative, given the fact that the Glendale battery storage facility is currently under investigation. And my attachment here says that units involved is undetermined. Therefore, I cannot answer that question in the affirmative.
I do think you are a mind reader, because my next question is battery thermal runaway a known risk for large-scale lithium-ion BESS facilities involving components of any type or brand?
Thermal runaways is a risk that is known throughout the industry, and one that the OEMs are quite aware of themselves.
Mr. Pucci,
Yes.
I wonder if you would consider asking these questions once their safety expert is present. And I certainly I understand that you're asking these questions right now as they relate to design. I would not preclude you from asking questions related to design on the day that we have reserved for safety. But it does seem that it's their safety expert who's going to be able to more, with greater authority, answer the questions, your design questions.
Yeah, no.
So
yeah, I appreciate that. But I'm not asking like for solutions or anything like that. I'm just asking about, the fitness for this intended equipment as a matter of project design, and also specifically with regard to the site selection. In other words, if you're talking about the possibility of wildfires that aren't caused by the facility itself, but if there's some fire incident and it engulfs this facility, something like that, these are questions that are relevant in terms of both site selection and project design. I mean, it's our position, this is just not an appropriately sited project for the scale proposed and the type of risk involved. And I know that thermal runaway incidents don't happen every day at these facilities, but as we know, the possibility of it happening, and then in connection with the siting choice specific to this is all relevant. It really doesn't go to safety issues as much as the suitability of the site selection, and then the fitness for these components and the scale of the facility proposed in this spot. So I'm not even sure I would need to ask these questions again of the safety expert, but I don't have too many more questions actually about this issue.
All right, well, go ahead and continue. Thank you.
Yeah, and actually, yeah, I'm done with the thermal runaway questions. In addition to now back to the panel, in addition to the thermal runaway possibility, the hazards and the risk of the facility, it scales up with the size of the facility. Is that fair to say?
I do not believe that's fair to say.
You do believe it's fair to say?
No, I do not believe that is fair to say.
Well,
asking me, and I want to be helpful to you and the board, but I am not the subject matter expert to discuss how many batteries are needed before a facility becomes more risk tolerant or less risk tolerant to your particular question.
Okay, and I promised the presiding officer I would move on, so let me move further down here. Hang on, just bear with me one moment. Actually, I can't help myself because to me, this is a matter of common sense. Fault currents can be enormous and dangerous at 180 megawatts, right? Resulting in the potential for electric shock and contact risk. In other words, these are dangerous places, right? At 180 megawatts.
Common sense says that all high voltage or low voltage electricity does have inert risks to it.
Best facilities at or above 180 megawatts also involve a risk of toxic gas emissions, correct?
That is not correct.
What is incorrect about that?
My understanding that based off of multiple studies that my subject matter expert has more experience talking to than myself is that there have been numerous studies, some that we've referenced in our IRs, that dispute that particular claim that you've just made.
Is it true that during overheating or failure, lithium batteries can emit flammable and toxic gases such as hydrogen fluoride, carbon monoxide, and hydrocarbons?
Again, I cannot speak to what would be emitted from a battery failure event. I have not conducted root cause analyses or done any sort of post-incident investigation like my safety expert has.
Do you know anything about those gases?
I do not know about those particular gases or gases really in general.
Okay. Do you know that those gases would pose an immediate risk to either a first responder or personnel at the site?
I do not know the risk to a first responder. I am not a first responder, but my safety expert is, and he would be happy to answer these questions.
At 180 megawatt scale, the volume of vented gas released during a fire event can be significant and impact air quality near the site, correct?
I do not believe that's correct based off of many of the attachments we've provided in the IRs.
Best facilities such as that proposed also involve, well, you deny that it involves that risk. Does it involve environmental and weather-related risk?
I'm not clear on what weather-related risks means with regard to environmental risks. As I've testified here a few times, that's my understanding based off of the reports that we've provided and the information we provided in the IRs to date, including a specific attachment issued by the state and the various departments within the state. That claim you've just made is not accurate.
Well, you're not clear about weather-related risks that I'm talking about. Let's use a specific example. In the event of flooding, say from heavy rains, water ingress could cause short circuits and corrosion. Is that correct?
Yes, water and electricity do not mix well. So yes, that's correct.
And extreme heat or cold can also stress battery thermal management systems. Is that correct?
I know that there is quite a range for what the safe operating parameters on the high end and the low end is for the batteries we proposed in this project. I do not have exactly what that is off the top of my head, but it seems to me that it's quite extreme weather, particularly for this region.
So I have some follow-up questions based on your Monday testimony and the questions that were asked from the siting board. Some of these go over to the issue of fan speed and noise, and I'm not asking about that. I understand the noise expert is not here. On Monday, I believe that, and now I'm talking about temperature extremes, that topic. On Monday, you testified that Tesla warranted that the units could operate safely at 40% fan speed to a max temperature of 36.7 degrees Celsius, or which is converted to Fahrenheit, 98 degrees Fahrenheit. Is that correct?
That is not correct.
All right. What did you testify? That's what I thought you testified.
I testified that that was the temperature that Tesla simulated and that was the temperature they used for their simulation of 40% fan speed and warranties, because that is the maximum recorded temperature of this region. I did not testify that that was the maximum temperature that these facilities can operate at.
I appreciate that clarification. I understand. So in other words, I guess put a different way, they don't have to operate at an excess of 40% fan speed as long as temperature is limited to 36.7 degrees Celsius, right?
That is not accurate either. I took a record request on Monday to have Tesla do a resimulation for more extreme temperatures to answer that question. Sorry, sir.
It's okay. Go ahead.
Did you get that answer?
I did.
Okay. All right. There's a disconnect here because I know I'm sitting here listening to you testify, and I know you just said they can operate safely at 40% fan speed to a maximum temperature of 36.7 degrees Celsius.
I did not say that, sir.
What is incorrect about that?
What I've stated in my testimony has been quite consistent on this, is that that temperature, 98 degrees Fahrenheit, is the temperature that Tesla did a simulation on to ensure that the battery fans could be operated safely and under warranty at 40%. I have also subsequently said multiple times that I have taken a record request to go ahead and ask Tesla to run a simulation to show that this could or could not operate higher than the temperature you have mentioned multiple times.
All right. So then you're saying, you're saying that if a temperature exceeds 98 degrees Fahrenheit, that doesn't necessarily mean they have to operate above 40% fan speed. Is that what you're saying?
That is what I'm saying.
Okay, I understand now. So but we don't know yet what the answer to that is, right?
Correct. I took a record request from the deciding board on Monday to further investigate this particular line of questioning.
Okay. And the temperature data that they took to determine that a maximum temperature in the area is 98 degrees Fahrenheit, when and how was that data collected?
Know where that email is again. I'm looking. Do you have an IR reference for us to help speed this along, sir? We're looking for the actual email that I was referencing extensively on Monday.
No, I'm following up on what you testified to Monday. You didn't reference anything Monday.
It was the email that Tesla sent us.
Yeah.
It was an attachment, so it was in parentheses something.
It's EFSB NO-9-1.
Thank you. EFSB NO-9(1).
Yeah.
Yeah. So as outlined in that said document, EFSB-NO-9(1), Tesla's simulation was based off of the 36.C degree maximum recorded hot temperature at the weather station at the Worcester Regional Airport, (DSB).
Okay, and that was for what, for 2025?
I do not know when that record was set.
Yeah, I mean, I'm asking for it in plain English. I would like to understand where they got the data. In other words, is it a one-time maximum temperature recording from a particular weather station at a certain point in time? And look at the document. I don't recall the document. I apologize. But if you can answer that based on what you're looking at, that'd be helpful.
Based on what I'm looking at, Tesla took weather data from the Massachusetts Worcester Regional Airport. That weather data that they used to simulate the 40% fan duty cycle says here in the document, record hot temperature 36.7 degree C. That's all I can speak to regarding this question.
Yeah, so I guess what I'm saying is we don't know much about that. In other words, we don't know, was that a one-time reading at a particular place recorded as the maximum for that time period or any particular time period? I'm just trying to get detail of what it is. In other words, is it an average over time? Is it over several years? Is it 1 year? Is it the maximum in 2025 at that point? I'm just trying to get what data was used to come up with the 36.7 degrees Celsius. That's not a trick question.
I'm not implying it's a trick question, sir. I will include your requests for how they got this data when I reply to record request the record request issued on Monday.
And
let's actually, just for clarity, let's make that another record request. EFSB dash RR, excuse me, RR dash EFSB dash 5. And basically what is the significance of the 36.7 degrees Celsius and where does that data come from?
Great, thanks. Regardless of where the data comes from, taking the 36.7 degrees Celsius maximum, we're talking about ambient temperature when we're talking about that, right? Like, in other words, if I'm standing outside, that's the temperature, right?
I do not know.
Do you know whether that accounts for heat on the interior of a BESS unit while the sun is beating down on the unit during the summer?
No.
And I'm going to give you a tortured analogy and not get too unpleasant about the analogy, but I would analogize it to a hot car in a parking lot. Say you didn't just hear my hypothetical through. And again, I'm not trying to be aggressive with you or give you a trick question, but just as a matter of common sense, you've got a parked car in a parking lot in the middle of summer with the ambient temperature at 98 degrees Fahrenheit. Is it fair to say that even with the windows cracked, the temperature on the interior of that parked vehicle is going to be unbearable compared to the 98 degrees outside the vehicle? Is that fair to say?
Using your analogy of if a car is going to be hotter on the inside with the windows cracked compared to how the temperature is outside the car,
yeah,
I would agree. Common sense has shown that the car will be warmer on the inside than it would be outside.
But when you have,
and I'm just going to interrupt real quick,
yep,
because I misspoke about the designation for that record request. I would like it to be RR-OAK-1. Sorry, back to you, Mr. Pucci.
Yeah, thanks. I think you answered the question. I was just giving the analogy of a hot 98-degree day. The interior of a parked vehicle with the windows even cracked open a bit is going to be much higher than it is outside the vehicle. Fair to say?
That is fair to say.
Yeah.
With regard to the car in your analogy, yes.
And then comparing it to BESS units, the same analogy would really apply, would it not? On a 98-degree day, you got the sun beating down on the BESS units. It's going to be a heck of a lot hotter inside the BESS units than it is in the ambient area.
I don't know if that's accurate given the fact that there's no windows. I believe windows do increase the temperature. I don't know, sir. I will ask Tesla, and
okay,
I will make sure that I answer this question via the people that are best suited to answer this question.
Yeah, and there is a point to my question. This is again a matter of common sense. Talking and
sir,
I'll get it.
I do appreciate what you're saying.
No, I have another question.
You're getting common sense.
Yeah.
Mentioned common sense a few times. I
Just,
can assure you
Mr. Benito.
Oh,
Mr. Benito, we just have to have one person speaking at a time. So let's let Mr. Pucci finish, please.
No, I have another question that I consider common sense, and you can correct me if it's not. What the point of my questions are, and I'm going to ask the sound expert on a different day about questions related to sound and 40% fan speed. What I'm getting at with you is, regardless of the ability of the Tesla unit to operate at 40% fan speed at an ambient temperature of 98 degrees, if it's hotter inside the unit, it's going to have to operate significantly higher than 40% fan speed in order to maintain temperature control. Is that fair to say?
I will ask my Tesla subject matter expert that question and get back to you.
And so those are the follow-up questions that I had from Monday on the temperature data issue and the issue of extreme heat or cold. Now I just want to move back to other project design questions. The risk of a wildfire in the vicinity of the project that is not caused by the facility itself is an issue of concern in this case where you're surrounded on three sides by acres of wooded area. Is that fair to say?
I'm sorry, sir. I was trying to get to the appropriate place in the IRs. Could you repeat the question?
The risk of a wildfire, even if it's not caused by the facility, it's certainly something of concern in this case where three sides of the project is surrounded by heavily wooded areas.
I didn't hear a question. I'm sorry.
Yeah, it's wildfires and the risk involved in possible wildfires a particular concern in this case where you're surrounded by wooded areas.
I still didn't hear a question, sir. Are you asking if I'm particularly concerned about this, about the woods around this particular site?
Yeah, is that a site-specific concern?
I would respectfully say that we need to ask my fire safety expert, who happens to be a fire chief and a first responder to scenarios that you are outlining in this line of questioning.
I'm taking a moment because I'm not going to ask you all these questions that you're going to give that same answer to. Hang on one second. Skipping particulars with regard to responding to a fire at such a facility, thermal runaway, do you agree at least that emergency responders would need specialized training for 180 megawatt BESS facilities?
I do agree, as outlined in our draft ERP, and based off of my understanding, speaking with my fire safety expert, that annual training is something that will be provided to the first responders in this town.
And moving away from fire risk or release of toxic gases, how about security and access risk? Do you agree that the facility is subject to theft, vandalism, or cyber attacks?
I do not agree that the facility is subject to theft. This is high voltage equipment, and were an activity like theft be attempted, there would likely be a catastrophic event for whoever was doing that action. With regard to what was the other part? Theft?
Vandalism. Vandalism was the next one.
Vandalism. Is vandalism like graffiti? What is vandalism? Please define vandalism.
Property, destroying property that is owned by the project.
This project as proposed will have security fencing, locked gates, and will be monitored remotely 24/7. I cannot speak to the higher or lower likelihood of vandalization and or thievery.
Monitored remotely, but you won't have any personnel located on site on a daily basis?
This facility, consistent with many facilities proposed like this, will be an unmanned facility. That means that this facility will not have someone out there 9 to 5 or regularly as you're asking.
Okay, my last question on that topic was cyber attacks. Do you agree that that's a risk? Yeah.
Cyber attacks, anytime, yes, cyber attacks are a risk. They are a well understood risk in the energy development and operational fields, and we would be operating this facility in accordance with all of those best management practices to go ahead and ensure that the facility does not have a cybersecurity event.
Yeah, how would you do that? Do you have anything in mind? Do you have any program that you've looked into or vendor, anything like that?
Not at this stage of design, no, sir.
How about theft of cabling components? Is that a possibility?
As previously mentioned, these cables will be high voltage, even if they were medium voltage or low voltage. Stealing cables, as you're implying, would lead to a catastrophic event.
Do you agree that there are indirect safety risks, such as that caused by battery degradation over time, which could affect performance and safety?
Battery degradation over time is acknowledged in the industry as well as within this proceeding. As such, we have proposed space and locations within the project footprint for augmentation. That augmentation will address the concerns outlined in this question.
I have a feeling I know the answer to this question, but I'm going to ask it anyway. Have you performed any plume, that's PLUME, modeling for a worst case scenario concerning release of toxic gases in the event of a fire?
As you may anticipate, I'm going to have to defer that question to my safety expert.
So you may have, you just don't know.
I just don't know. It's a question that my safety expert will be best suited to address.
Did you conduct any modeling to determine whether topography could result in gas accumulation in certain areas?
I do not know if modeling has been conducted in the industry for that topography related question.
Have you conducted studies or modeling regarding prevailing wind conditions relative to nearby receptors of released smoke or toxic gases in the event of fire?
I specifically, my company has not conducted wind analyses. I do believe, and my safety expert again could really help explain this for you. I do believe in our IRs, we have provided a few studies and responses that would address this question. Again, it's just not something that I'm qualified to speak to.
Can you tell us whether you...
Mr. Pucci,
Yep.
I thought we had moved away from the questions that were best suited for the safety expert.
No, this witness should know this. If the studies have been done, I'm not asking whether they should be done, what the results were, or why they may or may not be relevant, but this witness is the project developer. He should know what studies have been done. He just referred to one that apparently is in their IR responses, and I should be able to ask him questions about his knowledge about the suitability of the scale proposed and the site selection under the circumstances.
And what are you hoping to gain by asking him these questions?
In
addition to asking the safety expert the questions.
The utter lack of any type of independent verification or adequate study to make sure that this is a safe facility in the public interest being proposed in a rural residential district.
Right. I will allow you to continue.
Have you performed any site-specific dispersion modeling?
We have not.
Have you engaged in any independent third-party hazard analysis?
We have provided third-party hazard analyses. I believe it's labeled as the Fisher report and the And one other report that was provided, it's a very similar name to my company, and I apologize for not having it off the top of my head.
You don't have to apologize. Take your time and identify it, please. I know about.
It's attachment G of the petition, and it's the TUV Rinland report. Attachment F
I'm
is
sorry, TUV or PUV?
T, Tango,
Thank you.
and it's Rinland, but not like my company spelled. It's RHEINLAND. That's attachment G, sir, as well as attachment F. The Fisher report has conducted and as an independent third party, many of these studies that I believe you are asking about. I do acknowledge that I am the project developer and ultimately responsible for this project. However, I cannot recall this off the top of my head, and intend to rely on my safety expert who would be able to testify to these questions much more eloquently than I can.
You're perfectly eloquent. I asked you if you had independent third-party hazard analysis, and you just answered it. You said the Fisher report and the TUV Rinland report, right?
That is accurate, yes.
Okay. What hazard analysis have you presented to the community where you propose this facility, if any?
We have provided a draft emergency response plan and a draft HCA hazardous material assessment, in HMA, apologies, HMA and an ERP have both been provided in draft form in IR in this proceeding.
And that would encompass the. My next question was, had you provided emergency action plans, and that would fall within that, right? The draft emergency response plan.
That is accurate, yes.
Okay. In terms of a defined evacuation criteria, have you provided anything to the community in addition to anything that you just identified to me?
With regard to that question, I would respectfully request that it be directed to my subject matter expert, who would be much better suited to answer these questions.
Okay. Do you have any information concerning emergency evacuation triggers for the project?
That would be a question that would be best suited for my safety expert, Fire Chief Sean Morris.
In terms, again, of citing best management practices, do you agree that your proposed BESS facility abuts wildfire-prone vegetation on the site proposed?
You know, I don't know if I can agree to that because I'm not sure what constitutes increasing wildfire potential. I obviously know that vegetation can combust. That's common sense. I do not know what thresholds are required to or constitute the labeling of a wildfire.
Okay. In your responses to the siting board's first set of information requests, you indicated that you anticipate operation and maintenance of the project will be delegated to a third-party vendor. Do you recall that?
I do recall that. Do you have an IR that we can look up together?
I don't, but I forget where it is, but I read that. Does that sound accurate to you?
Yes, that is
okay.
accurate.
What is Moraga's role going to be in the project, if any, after it's built?
Moraga's role would be the owner and operator of the project. Essentially, that means that we are responsible for ensuring we have all the appropriate and necessary contracts in place for those specialized services to be conducted on our behalf to ensure safe and reliable operation of the facility.
And who is the anticipated vendor?
At this point of design and stage of development, I do not know.
Do you anticipate having to provide notice or seek approval of the vendor once the selection is made?
Approval for who?
Approval of whoever the vendor is selected to operate the facility.
I do not anticipate needing approval to select a vendor to operate the facility.
Because you're anticipating that Moraga is the owner operator?
That is our anticipation, yes.
Now, Moraga it's an entity formed only to pursue this project. Is that fair to say?
That is not fair to say.
Can you explain that to me?
Moraga was set up to develop, construct, own, and operate this facility.
But Moraga itself has never built or operated any other facility.
We have not currently built or operated other facilities at this time.
So in terms of maintaining ownership and legal responsibility in the event of any liability issues, would that be Moraga once the facility is in operation?
Correct.
With regard to decommissioning of the project, which is one of the listed topics for today, what is the full decommissioning plan and bond schedule for the project?
You have an IR that you're specifically referring to?
No, I'm asking you, what is the full decommissioning plan and bond schedule for the project?
Sir, I understand you're asking me. However, I know we've responded to this, so I want to ensure consistency and accuracy for the record by referring to our original response. Hence my asking you if you're referring to a specific IR. I can appreciate that you're not, and as such, I will take a moment to try to find it myself.
Yeah, please do. I didn't see it in there.
Could you please restate your question, sir?
Yes, what is the full decommissioning plan and bond schedule for the project?
As testified on Monday, the company is willing to make a commitment to provide a decommissioning bond or other suitable financial mechanism to the siting board within 90 days of operations.
All right, so I'll just ask a few follow-up questions about that. Then, so in other words, right now you don't have a decommissioning plan and bond schedule, correct?
Correct.
All right. So since you don't have that, you would not be able to tell us whether the decommissioning bond accounts for inflation and the full cost of removing batteries, transformers, and hazardous materials. You can't tell us that today.
Correct.
And you would not be able to tell us whether that bond is revocable, correct?
Correct.
Would you be able to tell us who controls release of the bond?
Without having those appropriate discussions, I cannot at this time.
If Moraga Storage LLC becomes financially incapable or ownership is transferred, who is responsible for decommissioning and ensuring regulatory compliance?
As is standard, if the company goes or becomes insolvent or sells interest in the project, all conditions, site approvals, plans would be transferred as part of that process to the new owner. In the event of a insoluble event, that would be worked out through the appropriate legal through the channels.
do you anticipate having an independent third party verify the adequacy of the bond and financial assurance?
I do not anticipate that.
Do you have an estimated decommissioning cost? And if so, what is that based on?
I do not have that.
What happens if the technology involved in the initial operations becomes obsolete?
Are you asking how long the batteries are, the life cycle of the batteries?
That and if the technology becomes obsolete.
But the project facility is proposed to operate, up to 20 years or more.
Okay, and what if, have you thought about that? What if the technology becomes obsolete? That Tesla Megapack, I'm not saying that this is the case, but say Tesla Megapack XL units turn out to be the worst thing ever invented for a BESS facility. What happens then?
It's not our expectation that that would happen. However, in the event of, for example, the Tesla Megapack 2 XL becoming replaced with a Tesla Megapack 10 XL, it would be our expectation that at the time we need to augment or do any sort of maintenance that would require or may require replacement. We would be then sourcing the most current and readily available technology at that time. That being said, if there were to be this scenario, it would be within the proposed limit of work that we've put in this petition.
Earlier you were asked more about the Mass DEP noise standards. And I was going to ask you about your lack of commitment to perform post-construction testing. It sounded to me that you're committing now today that you would conduct post-operation sound testing to ensure compliance with the Mass DEP noise policy. Is that true?
That was my testimony.
And what happens if you cannot meet Mass DEP noise policy once the facility is in operations? And when I say that, I don't mean, you may add a panel of sound protection or, in other words, additional sound mitigation components. What I'm getting at is, if you can't meet the noise policy, would you shut down the facility until you can? Or has anything been contemplated about that?
I don't have my noise subject matter expert available anymore. We had requested if he was going to be needed and was told no.
That's fair. That's fair. Okay, thanks. I'll hold that. One thing you may be aware of, are you aware that Mass DEP is currently reviewing the Mass DEP noise policy and is accepting comments that are ongoing for this? What?
Yes, I am aware of that.
Are you, what do you intend to comply with? The old noise policy, or if there's a revised noise policy as a result of that revision?
I have not been able to review the new noise policy, and without my noise subject matter expert providing me with the guidance to answer this question, I would not be able to answer it. I would not be able to answer that at this time because I don't know. I have not read the new guidance. And quite frankly, I have not read through all of the old guidance. I have the noise expert that provided that testimony on my behalf, or my company's behalf.
That's fair. Okay. We covered already Moraga Storage. That is actually an entity created specifically for this specific project, correct?
Correct.
Okay. And we've established this would be its first project, obviously.
It would be its first and only project.
Fred, we haven't had a ruling on this yet. And actually, I just wanted a little more detail about that. And Moraga's like a sole purpose entity. It's the owner operator of this facility. But with regard to, let's start out with construction of the facility. Say you get all the permitting you need and you're ready for a construction management plan, breaking ground, all of that. Is Moraga doing that directly at that point, or are you hiring somebody to do that? Is there a construction manager? What's proposed in terms of that?
Yeah, we've proposed that in your scenario where we have received all of the appropriate authorizations, we would then begin talking to capital providers and begin initiating conversations with engineering, procurement, and construction firms, EPC. Those EPC firms are the subject matter experts at construction, logistics, operation of bulldozers and the like, and would be responsible to Moraga and the contracts put in place by Moraga to ensure the safe construction of the project.
And then, so that's that stage. Then in terms of commissioning, what's the process for that? Say you construct it. What is the equivalent of, say, a certificate of occupancy that you're actually enabled to operate? Do you know what I'm saying? Like, who's responsible there?
I could talk very high level. Commissioning is a very detailed process that gets done with many specialists, as you can imagine, that are able to safely work around and with this high voltage equipment. That being said, there's typically a few stages of commissioning. There's a pre-commissioning. There's off-grid commissioning, i.e. It's being commissioned behind the meter, if you will. You understand, if you're familiar with that term. Then there's the on-grid commissioning. That commissioning phase is where we are testing all of the equipment while it's connected to the regional transmission infrastructure system. Then there's performance testing as part of the commissioning process. That performance testing is in line with what the title is there. It's to ensure that the facility is performing as expected. And then at that point, when all those stages have been thoroughly reviewed, this is over many months, then we would be ready to operate the facility and enter it into the regional transmission grid.
And is Moraga running that commissioning show at that point, or is there a specific entity that you hire to do that?
That is part of that specific entity I was referring to before, the EPC.
Okay.
That would be under that scope, under their expertise.
Okay. Then you're commissioned, you're able to operate. And then at that, you've already hired a vendor to operate at that point, right?
We would have, yes, sir. We would have already had that all contracted and well-defined.
Okay, and then day-to-day operations are by the vendor, but under the supervision and control of the owner, Moraga.
That is correct, yes, sir.
Okay. In response to Oakham second information requests, and this I do have numbers for you. It's many of them. Oakham 85, 86, 87, 85, 86, 88, 89, 90, 91, 100, and 102. Although these are slightly, address different financial components, essentially you refuse to provide any information concerning financing costs of the project, a cost estimate for the project, profit margin, anything like that. Why is that?
I believe this is a question of council.
We've objected to that. We've certainly offered to meet with the town. I believe the town would be entitled to that information in terms of a pilot and for tax purposes or even other agreements, but it certainly isn't part of a 40A proceeding.
So, Mr. Presiding Officer, and actually, I'm actually at the end, but with a reservation on a couple of these issues. So I don't see how the siting board can make a determination that a project is reasonably necessary for the convenience or welfare of the public if it's provided no information on the company's ability to carry out this project as proposed. So that goes to financing costs, cost estimate for the project. Clearly, they have to produce that in connection with this, even for alternatives analysis or anything like that. They have to provide financial information concerning the project. The other issue goes to the P&S agreement again. I'm seeking production of those purchase and sale agreements with the owner to see what's in those documents. I'm entitled to that and to ask further questions as a result of that. And I would also like to follow up. I believe if I haven't moved to compel responses to Oakham's second IRs, 85, 86, 88, 89, 90, 91, 100, and 102, I'm making that request now that I'm seeking to compel responses to those information requests. And if you need me to follow up in writing on that, I will. But I'm basically done with, and let me just be clear, I'm done with site selection and project design questions. I think I might have, decommissioning, that topic that you had on the list, which is for this panel of witnesses, including most of all, Mr. Benito. So I'm happy to stop here, just subject to a reservation of rights to follow up and ask further questions on the subject matter that I've just identified.
Thank you. Just one moment. Okay, that's noted. I would like you to put your request in writing regarding your motion to compel with respect to the second set of IRs. I would also ask the company and the town's attorneys to meet sometime tomorrow and to identify for me any items from the first set of IRs that remain in dispute. And maybe it's just a matter of clarifying, Mr. Pucci, that what you just spoke about was the extent of the items that remain in dispute. But I would like you to submit that by the end of the day tomorrow.
Okay.
Mr. Kaplan, I believe you had something to say.
Actually, if Mr. Pucci is going to put all this in writing, I can respond in writing. I was just going to point out, actually, I'll just wait and put it in writing as a written response.
Okay. So now would be a good time for us to take a break. So I'm going to suggest a 15-minute break where we resume at 3:10, which is actually a 16-minute break. But yes, sir.
I was just wondering if you knew which topics were coming up and whether Mr. Bergeron needs to stay or I'm not sure.
Well, good point. So let me just check if the other interveners have any questions on the subject matters that have already been questioned. So, Attorney Reich, will you have questions after the break regarding those same topics?
Let me get on. I'll have to look at my notes, Mr. Presiding Officer. I would prefer, since this was Mr. Ferry's witness in the beginning and he spent, a lot of time preparing for it, that rather than, do some scattershot cross that Mr. Ferry might want to supplement, that you allow us to come back when Mr. Ferry's back in town and do any cross, and there may not be any cross, but whatever cross he needs based on the testimony today.
So, and I was thinking specifically about the topics that Mr. Ferry did not address. You know, the general topic, the site, excuse me, the design, the decommissioning.
Yes, I don't know that Mr. Ferry was prepared to ask questions about decommissioning, but and I can check with him whenever he lands wherever he's going. And it might be, it might be very late tonight. I can try to check with him, but I don't know that. I know the focus, his main focus was going to be on issues of site selection.
Yeah, well, it was really whether you wanted to ask questions on those topics.
I'm not going to ask any questions on site selection. I mean, other than the two issues that I raised with you, prior to or right after the break, which is we still don't have those agreements, which Mr. Pucci has rather eloquently said why we need them. I'm not going to repeat everything that he said or that I said, but so I can't ask any questions about those documents till we get them. Obviously, if we don't get them, then there won't be any questions. As to energy issues, he is our energy expert, so I don't intend to ask any questions on energy. That would have, anything that he didn't ask the first time or that might have come up since he's left the country. I'd rather reserve for him.
And do the Salpes have any questions for the company on the topics that have been discussed so far? I ask that assuming they're not here, but I just wanted to make sure. Can we just go on? We're going to go on mute real quick. So after the break, we will continue with day two's topics. The board staff will be asking questions on those topics, starting with traffic, construction, hazardous materials, and zoning. If time permits, we may ask the town to ask its questions on those same topics, but we will evaluate that more later.
May we make it 3:15 now?
Yes, sir. 3:15 off the record. Thank you. think we're almost ready. I thought I would just wait till 3:15. And we will be starting with you, Mr. Chang, right? Mr. Brock, we'll just give it another little bit. Let us know when you're ready, please, Mr. Kaplan.
You're ready.
All right, on record. Mr. Chang, please.
Thank you, Hearing Officer Kelleher. To the company panel, please refer to Exhibit EFSB-T, as in Tango, -7.
I have EFSB-T-7.
The company stated that various elements of traffic impact could not be determined until a engineering, procurement, and construction contractor, as referred to a EPC contractor, is selected, and that any responses at this time will be speculative. Notwithstanding the company's response, the siting board requires at least some information to assess project traffic impacts, even preliminary or planning level information. And so that's the context of the following questions. Please provide estimated daily trip generation during construction, differentiating between passenger vehicles and heavy vehicles such as trucks, and provide a range if necessary.
I don't have that estimate available, so I would respectfully request a record request on that.
Sounds good to me, Hearing Officer. I would like to make a record request on that.
All right, we will assign the designation RR-EFSB-5.
I can put in the record. The record request is for the company to provide estimated daily trip generation during construction, differentiating between passengers vehicles and heavy vehicles such as trucks, and provide a range if necessary. And I'll ask the second part of my question. The company stated that the project would be remotely monitored during operation, and traffic to the project site would be limited to periodic site inspections and maintenance visits. Please estimate the frequency of these visits and the amount of traffic each visits would generate.
The frequency of those visits and the amount of traffic that they would generate certainly be associated with the specific operation and maintenance that needs at that time. With that said, in discussions with the OEM, typically we're talking about two individuals that would be visiting the site for routine maintenance. Those individuals would be in a vehicle, typically of a pickup truck or a van, a utility van of sorts.
And how frequent would those, what's the rough frequency of those visits, if they are regular or if they are irregular?
There is regular maintenance and there is a cadence schedule associated with that, but unfortunately, I'll have to take a record request to pin that down. after discussing with the OEMs.
Would that information be available by the deadline of the record request?
I'm sorry, could I hear that again, please?
Okay. Would such information be available by the time that by the deadline, the company would need to submit a record request?
Yes, I believe this is something that I could act on relatively quickly. It's just not in front of me, but it is something that we have an understanding of currently. Unfortunately, I just don't have that material here. So yes, I think it would be something we'd be able to respond to in an appropriate time.
Sounds good. Hearing officer, I think although they're related, this is a little different than the previous one, so I would request to make a different record request.
All right, this one will be RR-EFSB-6.
So the company would submit, let's see, the frequency of the maintenance visits while the project is in operation.
Understood. Thanks, sir.
For the next question, we'll stay with Exhibit EFSB T7. Tell us more about what the company anticipates the site-specific logistic plan would include.
The site-specific logistics plan would include information such as where folks would show up, so where the construction crews would, where they would arrive to and stage their vehicles for the project. That plan would also involve site-specific conditions that they should be aware of to ensure that compliance is being met. Some other site-specific logistics plan information would include like frequency of the personnel, the approximate number of personnel, times and days where that personnel would be on site, things of that nature.
And to add to that, would that include also any details regarding special large deliveries?
It would fall under that plan with regard to ensuring that those large deliveries or heavy loads are being well thought through in terms of how they're going to be getting to the site and particularly where they will be going once they get to the site.
Thank you. Tell us more about what the company anticipate the collaboration with the town department should entail regarding the site-specific logistics plan.
Some things that we would anticipate getting from the town or achieving a better understanding from the town would be, are there, for example, particular town events that we should be aware of? Are there particular road closings or challenges with access along the routes that we've identified that we should be aware of? A part of that plan would be us working with them to ensure that if needed, we had appropriate flaggers to direct and guide equipment. That would be some of the things that we would be talking about from our perspective and looking for the town to provide guidance on in that plan.
Thank you. So staying with the same exhibit, on the next sets of question. For the need for off-site staging space not yet identified, describe the factors in determining such sites and whether the project parcel would have adequate space to accommodate contractors' vehicles and equipment parking, staging, and laydown for the entire project construction.
Yes, we believe we've laid out in the petition a limit of work that would accommodate the showing up of vehicles, the staging of vehicles, as well as equipment. That being said, the need for off-site staging or not would be best discussed with the EPC once we have a better understanding of how they plan to execute the construction phasing day to day of this facility.
Thank you. For clarification, so my understanding is, from your response is yes, the limit of work could accommodate everything, but depending on discussion with EPC, off-site staging space might be necessary.
That's correct, yes.
Okay, thank you. Regarding, let's see. Regarding the off-site staging space, which could be necessary, discuss how the company would approach finding additional staging and laydown area.
Those areas would typically be previously developed areas. So excess space in parking lots, excess space that we could find that has the availability that's to show up and park those vehicles, and then perhaps carpool those laborers and site-specific folks to the site. If it's more advanced and needs to be for equipment, that site would then have to be secured. It would still be, to the best of our ability, on an area that has already been previously developed, so as to ensure we're not adding any sort of environmental impacts to the project as presented in this proceeding.
Thank you. Now, if the company has started looking at it, I'm not saying it has, but in case it has, does the town of Oakham have any such potential off-site staging space, or would you be looking beyond the town limits?
We do not and have not identified or begun this process, but it is customary to look at sites as close to the project facility as possible. However, many times, or that may not be available, and that show up site or staging area could be outside of the town of Oakham.
Thank you. For the next sets of questions, we'll stay on the same exhibit, but with the addition of exhibit EFSB-CM-10.
Okay, I am CM. I have both EFSB-T7 and EFSB-CM10 in front of me.
Great. While the company has not finalized specific on-site locations for equipment storage, contractor parking, staging, and construction laydown, would the company commit to locating these areas outside of wetlands, vernal pools, other water resources areas, corresponding buffers, and other environmentally sensitive areas?
Yes.
Thank you. We'll move to the next topic on solid waste and hazardous materials. Please refer to Exhibit EFSB-H-6, open parentheses 1, close parentheses.
Sorry, could you repeat where in, what IR? I'm out the area.
Certainly, it's EFSB-H-6, attachment 1.
I have it in front of me, sir.
Okay. Has any or all of the mediation recommended by the Phase 1 environmental site assessment dated May 2022 taken place?
The findings of this Phase 1 environmental site assessment and limited subsurface investigation of the subject property at 358 Colebrook Road has identified a few things like drums and containers to be removed from the site. At this time, the company has not done that.
Does the company intend to implement it as part of this project?
Yes.
Thank you. We'll move to the next question. Please refer to Exhibit OAK-19 and the associate attachment OAK-19, parentheses 1. Through actually parentheses 7, so there are 7 attachments. Oh, wait.
I have EFSB-O-19.
Give me.
Could you please clarify that you're directing us or me
No,
to EFSB?
I actually need a minute. I think I have the wrong reference as well. So if hearing officer, we can take a minute to make sure we have the correct exhibit numbers. Okay, thank you. Okay, I'm back. Sorry for the confusion. I was referring to exhibit EFSB-OAK-19, and that's to differentiate with the exhibit with just the OAK. The EFSB-OAK.
I'm sorry, that's to differentiate what?
Exhibit that is only containing OAK prefix. The EFSB-OAK prefix are the IRs that we, the siting board, have sent to the town and got responses, whereas the OAK is the ones that the town have directly submit information requests from the company. And to get the record straight, I'm referring to exhibit EFSB-OAK-19 and its associated attachments.
I have them.
Thank you. My question. Describe the current situation regarding materials, including car parts, car frames, and metal drums found on the northern property boundary shared with the DCR conservation area.
Sorry, and metal drums found on the
Northern property boundary shared with the DCR conservation area.
Thank you.
So the company is aware of the various car parts and components that are along the northern boundary and intermingle with the property line fence, as indicated in these various attachments.
Does the company know whether the property owner has responded to DCR?
The company does not know if the property owner has responded to DCR.
Has there been any effort by the owner of the project parcel or the company, including with or without coordination with DCR or the town, in addressing the DCR request to remove these materials?
I believe that DCR request I see here that DCR request was made January 30th, 2026. As of today, the company has not worked with the town or Mass DCR or with the current property owner on this request.
In addition to the referenced exhibit, please also refer to the exhibit MS-A supplement 1, which is the revised site plan.
I have the revised site plan here.
Okay. Please confirm whether or not the latest project site plan shows the construction area bordering the aforementioned northern property boundary, where materials including the found car parts, car frames, and metal drums.
I believe, as shown in that letter in figure 2-3, the arrow that points to mutual boundary discussed is within the company's proposed limit of work. Sorry, excuse me, one correction. Is within the area of the company's proposed limit of work on the subject parcel. The company that does not have, or has not proposed the limit of work to be on the other side of the fence where I believe many of these pictures were taken from.
Okay, to further verify that, so you're saying the companies, let me rephrase, the area of the proposed limit of work cover one side of that fence line of interest.
That's correct.
Thank you. Does the company anticipate the project construction and operation would worsen the current situation, including further disturbance to this material and further affecting the DCR property?
No.
Can you explain why not?
The company has not proposed to has not proposed to disturb Mass DCR property at all. Therefore, we would not be increasing the identified issue here on Mass DCR property.
And to clarify on that, would any work within the area of proposed limit of work
Sorry.
If you can let me finish, directly or indirectly worsen the situation on the DCR property?
It is not the company's expectation that the project as proposed or the limit of work identified on the revised site plan would increase or further add to the situation that's currently represented in this January 30th, 2026 letter.
Thank you. If an enforcement action by DCR over the materials were to transpire, how would such action affect the project construction and operation?
I think that would be dependent upon what that action that you referenced there entails. The company and the project has interests in the subject property site. However, the company, it's my understanding, the current owner was not involved in the placement of this material on DCR property.
Thank you. I couldn't really speculate or possible scenarios where enforcement action may entail, but reasonably I can think of is a cleanup on both sides of the fence. And if that's the case, how would such a action affect the project construction and potentially operation?
I don't believe there would be a material impact to the construction and or operation if there were to be an enforcement action requiring the cleanup of the area around this shared property line.
Can you explain a little bit of how do you come to that conclusion?
I come to that conclusion because any cleanup of that area would likely be done before construction or before construction or after construction. Quite possibly could be done during construction if the available equipment is not being utilized at the time for actually maintaining the construction schedule.
And how about if it happens during project operation, would that impact project operation?
I think it would really depend on the scale of this cleanup, whether it requires heavy equipment or if it can be done with just laborers, wheelbarrows and the like. So I think it would really depend on how entailed that cleanup would be required. And at this time, I have not gone out there specifically to look at, all of this information being presented here. Some of it looks quite heavy, so may need some heavy equipment to move. That being said, sir, I can't really speak to the nature of how we would respond to that enforcement action other than to say and commit to the fact that any regulatory action or requirement will be adhered to by the company, by the project.
Thank you. I'm trying to focus on the impact on the project, or rather than how that implicate on the company. So and just to follow up on one more aspect, notwithstanding there's only certain level of details that we can or you can determine at this point. If the cleanup does require heavy equipment, would you anticipate any interruption to the best facility operation?
I would not. This area appears, I would not, because this area is outside of the physical footprint proposed for the substation, batteries, and associated ancillary equipment.
Thank you. And I have one more zoning questions. Please refer to Exhibit MS-1, page 31 through 38. That's the analysis, the company analysis for the project, page 31 through 38. And also, I'll refer to the site plan, MS-A, supplement 1.
I have MS-1 at page 31. Mr. Bergeron has handed me the other supplemental, has handed me the supplemental plans here, EFSB 25-07.
Great. In light of the site plan revisions, are there any updates on the individual exemptions, the zoning exemptions, requested for section 5.3 and section 6.3 of the Oakham zoning bylaws?
If you give me a moment, I just need to confirm what those sections in the bylaw refer to.
Please take your time.
Zoning bylaw, that's one of these. I think it's here. Could you please restate what sections of the zoning bylaw the question pertains to?
Happily, is sections 5.3 and section 6.3.
Section 5.3, lot line regulation. No structure shall be erected within 50 feet of the sideline of a budding lot nor 50 feet from the front lot line.
Sorry, I'm having difficulty understanding you. No structure shall be erected within.
50 feet of the sideline of an abutting lot nor 50 feet from the front lot line. There's no change to the need for relief from section 5.3 associated with the revised site plan.
Thank you. And how about section 6.3 of the Oakham zoning bylaws?
Section 6.3 addresses removal of soil. There is no change to the need for relief from section 6.3 with the submittal of the revised site plan.
Thank you. And are you aware of any other changes that the revision might need for individual zoning exemptions?
No, I am not.
Thank you very much. And hearing officer, that concludes my questioning on these topics.
Thank you, Mr. Chang. Mr. Pucci, if you could pick up with questions you have on these topics, please.
Yes, on the issue of traffic, I would like to ask questions when we get the response to EFSB 5. That was my major points of questions in terms of traffic today, were the number of truck trips going back and forth and what they were carrying and the size of the materials. So if we're anticipating further questions after they respond to that, I would like to reserve the right to ask that. I do have a couple of questions I could probably ask on the issue of zoning right now. You want me to go ahead with that?
Yes, that would be fine.
Thanks. Mr. Benito, I was very confused about your testimony on Monday about the AG approval of the bylaw prohibition, site control, and related issues. And I'm going to try to say to you what I understood that testimony to be, and then you can correct me. I believe that you acknowledged that the company had site control before the AG approved the bylaw. Is that correct?
That was my testimony, yes.
Yeah, and do you recall when that was?
As laid out in the memorandum of option, November 12th, 2022.
And the documents which have been withheld from production that are referenced in the option agreement, do they provide further information that would be relevant to when the company first was interested in this parcel, when they entered into any type of transaction with the owner or had any type of negotiations?
These documents do not identify when the company's interest was in this parcel. These documents, public or otherwise, acknowledge the company's interests were secured on November 12th, 2022.
And then I didn't, I'm going to try to understand your answer on knowledge of the bylaw prohibition. I believe that you said that the AG approval of the bylaw prohibition came after you acquired site control. Is that correct?
That is my understanding, yes.
Yeah. And then you were asked questions about, and this is just a matter of law that nobody's going to disagree with, but I think Attorney Ferry, I believe, was the one who asked you, the AG approval only goes to if she found the bylaw invalid. But when she found it valid, that meant the date of when it became effective related back to when the town approved it. Is that your understanding?
Look, I don't have case law or case study experience in zoning regulations like this.
Okay.
I understand that that's what you've presented.
Yeah, I mean, that'll be it's a matter of law. We'll put it in the brief if we have to, but to understand your testimony, why was that even relevant? The AG approval of it, because you're going forward with the project knowing about the bylaw prohibition. In other words, what relevance does that have, the AG approval?
In my opinion, it doesn't. This AG approval discussion and line of questioning is in response to a question in an IR asked of the company, which I can find here hopefully quickly and help direct us towards. I'm turning to OAK-4. This line of questioning regarding the Attorney General is happening due to our response to Oak-4, where the question specifically asked the company why it chose the site when the town had a bylaw and was the sole municipality that had said bylaw. The company's response was that we thought we were answering the question with was that we had acquired those rights before the Attorney General had approved the bylaw, which we understood when we responded that that was what the question was seeking.
Oh, yeah. So yeah, so that is getting to my question. To clarify, really the AG approval of it really has nothing to do with your decision in terms of site selection, knowing about the bylaw prohibition. In other words, if she had approved it before you got site control, it wouldn't have stopped you from going forward with the project.
Could you repeat the question?
Yeah. It looks like the date of the AG approval of the bylaw really had nothing to do with your site selection in face of the bylaw prohibition. Because had she approved it before you gained site control, you still would have gone forward with the project petition, correct?
That's correct.
Yeah. So I have going back to the original line of questioning is what analysis did you do, or what was the decision making behind, from a site selection viewpoint, going forward with a project when you knew that there was a standalone best facility bylaw prohibition in zoning? did you have any internal discussions or concern about that before you went forward with the project?
Our interest in the subject property predates the Attorney General's approval of the zoning bylaw, as well as the June 2022 bylaw being proactively approved.
Okay, so there was no bylaw prohibition, whether approved by town meeting or approved by the Attorney General, as of the time you acquired an interest in the property. Is that what you're saying?
No,
In other words,
we acquired an interest in the property on November 12th, 2022, which is after the bylaw that was approved by the Attorney General was retrospectively active. My response to your question is that our company had interests in the subject property before that bylaw, retroactive or otherwise, was put in place.
Okay.
i.e., our company was already working on securing site control before the late June 2022 bylaw was voted on and subsequently approved a few months later by the Attorney General.
So, right. So, and when we use the term interest, we mean like the dictionary definition of interest. We don't mean, a property interest. In other words, you as a company, as a project proponent, were interested in possibly siting it at that location. You didn't have a property interest in it at that point.
We did not have a signed real estate contract that predates the bylaw from June 2022. What I'm trying to explain or share with you is that our company was already in discussions with real estate brokers prior to that bylaw being enacted and then approved subsequently by the Attorney General.
And then had you known, if the bylaw had been approved before you undertook those activities, would that have affected you at all in terms of going forward and seeking site selection here?
Prefer not to engage in hypotheticals like that. I would be a case-by-case decision that I would make with my company and colleagues based off of many discussions. But with regard to your question in this particular subject property, I cannot say whether we would have or would not have moved forward with securing an interest on November 12th, 2022, had the bylaw not been in place or had it been in place prior to that exercise, if that makes sense.
It does make sense, yeah. And so my last question on it would be, once you did learn of the bylaw, both approval at town meeting and the AG approval, did you have internal discussions about that subject matter along the lines, in substance, discussing, do we want to go forward with the site knowing about this bylaw prohibition, or should we just, should we either consider pursuing another site location in another town, or do we want to go forward and try to get an exemption from that prohibition? Does that make sense?
That does make sense. And by the time that the bylaw was approved by the Attorney General, we had already been under contract with the property owner and had already had a significant financial interest in this subject property.
Okay, Mr. Presiding Officer, those are all my questions. Follow up on the topic of zoning, construction and traffic. I just have possibly some follow-up questions once we receive the response to the record request from earlier. And then on hazardous materials, I don't really have anything beyond what I would ask in connection with a fairly short cross-examination on the wetlands and water resources issues that you have scheduled for a subsequent day. So I would be comfortable stopping here.
So that is the end of the questioning on day two's topics, correct?
Correct.
I did check with, I mean, I'll double check with the interveners. I did ask before the break whether they anticipated any testimony. Mr. Reich indicated no from himself. Are the Salpes present? And if so, would they like to ask any questions? So, Mr. Reich, I may have asked you specifically about day one topics only. Do you have any questions, Mr. Reich, regarding the day two topics?
I do have a few questions.
Go ahead.
Let me just. So I'm going to ask first about the site assessments, and I will need a little help in locating some of these documents. I'm going to ask questions about some documents, but I don't readily have them in front of me because I wasn't anticipating doing this exam today. So let me start. This would be for the panel, whoever's best to answer the question. The first question is, you mentioned, I think, one or two, maybe even three site assessments that have been conducted at the property. So this is a question for anybody on the panel, if they can let me know how many site assessments are they aware of the proposed site for the BEST facility.
Yeah, the site assessment and limited subsurface investigation shown in EFSB-H-6 parentheses 1 is the only environmental site assessment conducted to date that the company is involved with or has knowledge of.
And what is the date of that assessment?
May 2022.
Okay, and who conducted it?
The firm that conducted it is called SWC, as in Charlie, A, Environmental Consultants.
Okay, I didn't get the first letter. Was that S or
S.
F?
S as in Sam.
S as in Sam. Keep going. S what?
W.
Yep.
C.
Yep.
A.
And what was the rest of their title?
Environmental Consultants.
Okay. And who retained SWCA consultants to do the site assessment?
This document was provided to us during our due diligence of the property, and it was prepared for by the current landowner.
And who is the current landowner?
This was prepared for BHT Properties Group.
Okay. Is that the same group that made the application to the planning department to put in an auto storage, an auto auction facility?
One moment while I pull that information up. Yes.
All right. Is Mr.
Sorry. Excuse me. I want to correct my answer there. as I'm seeing on EFSB T-10 parentheses 1, the applicant was BHT Oakham LLC.
Okay, what was the FB number again? EFSB what?
T Tango.
Yep.
-10.
Yep.
Parentheses 1.
Right, so that was the entity that went forward with the proposal for an online auction facility? Is that what you're saying?
Yes, that is correct.
And the name of that group was, again, is what?
B as in Bravo, H as in Hector, T as in Tango, Oakham Limited Liability Corporation, LLC.
Okay. And who are they?
It says on here, the owner's name is Cynthia Pally.
Okay.
P as in Papa, A as in Alpha, L as in Lima, Lima, Echo. Why? Yuma.
I thought that Miss Pally was the owner of the property before it was taken over in ownership by the Florida entity that is owned by Mr. ZOYL.
I'm sorry, that is owned by Mr. What?
ZOYL. I don't know if I have that spelled right and I can't pronounce it.
All I can answer, sir, is that's who's identified on this application you asked me to refer to. The applicant is BHT Oakham LLC, and it identifies the owner as Cynthia Pally.
All right. And so this was the entity BHT Oakham LLC, BH Oakham Company LLC. That was the applicant on the applicant or owner, strike that, applicant on the proposal to the planning department in 2022 to develop a online auction site. Is that right?
Yes, it's yes,
right.
That is correct.
All right. Who is BHP Property Group?
BHT Property Group has an address of 5555 Anglers Avenue, Suite 27 in Fort Lauderdale, Florida, 33312.
And you know whether a Mr. Zoll, if I've got that pronunciation and name right, is affiliated with that group?
My understanding is, did you say Mr. Zobel?
No, ZOYL, I think is how it's spelled. I may have that wrong. It's a gentleman that's at that address.
There's 2 emails identified with folks at that address in the application for special permit dated
Right.
February 2022.
And who are those individuals?
Ram, R as in Romeo, A as in Alpha, M as in Mike, at BHT Properties Group.com. There's also Design, DESIGN, at the same email address identified on this application for special permit.
All right. Maybe I can cut to the chase. In the memorandum of option, which was earlier given an exhibit number, I don't have the exhibit number in front of me. It's between Moraga Storage and Zovel, ZOVL Properties LLC. Was Zovel Properties LLC or Mr. Zovel affiliated with the entity that was the entity that was the entity that did or conduct or on whose behalf was conducted a site assessment back in you said 11/22. That this is that the same individual?
So it's the same individual that the site assessment was prepared for
Right.
is also the same entity or individuals that are in the special permit application.
Okay. And is Zoval Properties, are they the current owner of the property?
Correct. Zoval Properties LLC is the current owners of the property.
And do you know when they first obtained ownership of the property?
I do not know,
Uh,
but presumably based off of the application we just reviewed, where the owner was identified as somebody else.
Right.
Could have been 2022.
All right, then let me go to, let's switch topics for us, not topics, but just as long as we're on this train of thought. In the memorandum of option to purchase agreement that we just referred to, there's a reference to a real estate purchase and sale contract dated November 12th, 2022.
That's correct.
And who is that real estate purchase and sale contract dated November 12th, 22? Who are the parties to that contract?
Party to that contract, Moraga Storage LLC and Zoval Properties LLC.
And Zobel Properties LLC, that's the entity you just named, correct, as the owner of the property?
Correct.
Okay. So on November 28th, 2022, Moraga and Zobel Properties LLC entered into a contract, a real estate purchase and sales contract, correct?
One point of clarification, November 12th, not November 22nd.
All right, you're right.
Other than that, yes.
No, thank you. I wrote down the wrong date. So what was the, have you seen that contract?
Have I seen the contract referenced here from November 12th, 2022?
Yes.
I have seen it.
Okay. Can you summarize? Let's just start in general. What was the purpose of that contract?
The purpose of that contract was to establish site control and rights with the subject property we've been discussing in this hearing.
Okay. And when you say site control by Moraga?
Correct. Site control by Moraga.
Okay. Prior to the date of this contract, November 12th, 2022, did Moraga have site control of the property?
No.
No. But I think you testified that you had discussions and even were talking to brokers and so forth about this property, correct?
That testimony is correct.
And how much earlier than November 12th, 2022 did you start those discussions?
Those discussions were begun before those discussions were initiated at least in May 2022.
Okay. But not earlier?
Not to my recollection.
Okay. Were you with Moraga in May of 22?
I was not.
Okay. Is there anybody on the panel that has better information than what you have about a contract signed before you were with the company?
I am the identified witness to discuss this. There is nobody else that is better suited to answer these questions.
All right. Is there any document you can look at or any series of documents you can look at to perhaps refresh your wouldn't be recollection, that can inform you as to when Moraga and Zobel began discussions?
Moraga began discussions with a real estate broker around the time frame I just outlined, May 2022.
Okay. Did you have any discussions prior to that date? Same question I asked before. To your knowledge, were there any discussions prior to May of 22 with the real estate, with the owner of the property or anybody else?
No, to best of my knowledge, those discussions were kicked off on or about May 2022.
All right. This real estate purchase and sale contract, did it have any kind of an option agreement in it? Similar to
It did.
Okay. And what was the term of that option? What were the terms of that option agreement?
Terms of those options are company proprietary, and disclosing them in a public forum like this, sir, would put our company at a disadvantage, an uncompetitive disadvantage.
I'm not asking for the financial terms. I'm just asking for a description of what was the purpose of that option agreement.
The purpose of that option agreement was to allow for the development, site survey, and allowed Moraga storage and its proxies to enter the property to conduct environmental surveys, to conduct land surveys, to essentially develop the property as we're doing, getting through the permitting processes to allow for the ultimate exercising of that option to purchase agreement.
Okay. So this agreement, just to summarize, is it correct to say that this agreement was intended to give Moraga full access to the property without actually owning it, but full access to conduct appropriate surveys and other assessments for you to determine whether the property would be suitable for a BESS?
That's exactly correct.
Okay. And at that time, were you looking at developing the property for an auto park?
No. As previously testified, Moraga Storage LLC is a standalone battery energy storage system developer.
Okay. Did anybody on your behalf, was anybody on your behalf trying to develop the property for a auto park as referenced in the 2022 and 2024 petitions to the Planning Board of Oakham?
No, Moraga Storage was not involved in that special permit process.
Were you aware that that permit process was going on?
Part of our due diligence for this property during the due diligence for this property, it was discovered that the property had or was going for a special permit with the town of Oakham.
Did you have any discussions with Zoval Properties LLC or any of its principals about those two permit applications?
No.
Did you assist them in any way with those permit applications?
No.
Did you pay any money to allow them to proceed with that permit application?
We did not finance or fund in any manner that permit application.
I understand they had a lawyer in at least one of the proceedings for that permit application. Did you hire that lawyer or strike that? There's a recently added town meeting record on Zoom. When I say recently added, I think very recently added, that has a video of one of those proceedings. I think it was the 24, but I don't hold me to that. And there was a lawyer at that proceeding. Did you engage that lawyer to assist Sobel with that proceeding?
As previously testified, we were not involved in that proceeding financially or otherwise in any manner.
Okay, well, I'm not, yeah, I'm being more precise. Did you provide any
No.
compensation to Zobel in connection with that
I'm
proceeding?
sorry, did you provide any what?
Compensation to Zobel or its representatives?
As part of this purchase and sale agreement, there has been financial contributions from Moraga Storage LLC to Zobel Properties LLC. However, Moraga Storage has not and was not involved in any special permit, any hiring of lawyers with regard to that previously approved permit through the local planning board.
Did you attend either of the two planning board meetings with respect?
Not to my, I did not, as previously testified, I was not part of the company. My understanding through discussions is we were not involved or attending any of those proceedings.
All right, but you became aware of them, the company became aware of them around the time that they took place? Is that fair?
I'll have to go back into my records to see when we became aware of them. What I can say, what I believe we've provided in one of these IRs is the special permit. And that special permit was provided to Moraga Storage, to my company, during the due diligence phase of this real estate transaction. So it might be important to note that, as is very typical with these sorts of development, companies like mine take interest in them through these agreements, but don't exercise those rights until and after all of the due diligence, site surveys, and necessary local, federal, or state approvals are in hand.
I understand, but you did take a more than an interest. You actually signed a contract in November 12th, 2022 for the site that's in question in this proceeding, correct?
Correct. That November 12th, 2022 was a purchase option agreement. An option purchase agreement outlines exactly what I just mentioned.
Yes. Okay. You indicated that you paid some money to Zobel over the course of that agreement. And that agreement, was that agreement amended in August 29th of 2024?
That amendment that agreement was amended on August 29th, 2024.
Okay. We will return to the amendment in a second. In terms of the agreement itself, did you pay any money to Zobel pursuant to that agreement between November 12th, 2022 and whenever that second agreement expired?
There have been payments to Zobel from the company during that period you just laid out, November 12th to August 29th.
Well, I presume after August 29th, because that was the date of an amendment. So it must have had either it had a termination date or it didn't. And as I say, we'll get to that, but I presume it would have gone past 11/29 because that was just the date of the amendment, correct?
The amendment was 8/29, August 29. And what was the rest of the question? I'm sorry, I missed it.
Well, when that amendment was made, did the amendment contemplate further contact and further contact and cooperation between Moraga and Zobel for some period after August 29th, 2024?
Yes, the August 29th, 2024 amendment to the option to purchase is ongoing and valid at this time.
Okay. So that agreement's in effect, even though the memorandum of option agreement was entered into January 16th, 2026. You're saying that the earlier agreement is still in effect?
Yes. This memorandum of option is in response to requests for company proprietary data, and it merely summarizes some of the key points that we think are most relevant to this proceeding, specifically our site control on the subject parcel.
All right. So you're saying that, if I don't want to put words in your mouth, but you're saying that the memorandum of option to purchase agreement really just more or less outlines for the record, as you said, because I understand it was recorded, outlines for the record the contents of the earlier agreement, November 12th, 22, and the amendment dated August 29th, 24. Is that fair to say?
That is correct.
Okay. So without getting into the dollar amounts, what payments, what was the purpose of the payments made to Zobel in the period 11/12/22 to the present?
Those payments ensure that we maintain our interest in the subject parcel as outlined in this proceeding.
All right, I'm not, so what do you mean what do you mean by saying that it was to maintain your interest in the property?
What I'm saying is that there have been payments to the property owner under these agreements that outline our continued rights to access, develop, survey, and to access, survey, and develop the subject parcel.
Were these periodic payments? In other words, were they made on a certain schedule?
They are on a certain schedule. I can say that publicly, yes.
Is it fair to say that this was, if you had leased the property and were making lease payments to Mr. Zobel, it would be equivalent to those kind of payments?
Without having a lease agreement to reference, I would be comfortable saying that they are likely similar in manner to what I believe you're asking.
So it's paying Zobel to give you access to do all the things that a prospective owner might want to do, and to make sure that Zobel doesn't go give that same option to another entity, correct?
That is correct, yes.
So were there other payments made to Zobel besides these periodic payments?
Not to my knowledge.
Zobel wasn't paid for, I don't know, special access to the site, well, strike that. Okay. So what kind of, you said you only made one site assessment. You were provided one site assessment by Zobel, but have you made subsequent site assessments of the property since 11/12/22?
Sorry, I have difficulty
You
hearing.
made subsequent site assessments of the property since.
I'm sorry, you went over each other.
Okay. All right. Ready?
Yes.
Since November 12th, 2022, have you made any site assessments other than the referenced site assessment of that date was 5/20/22? No. You mentioned the first site assessment. I'm not sure I have the date of it, but have there been other site assessments made by you or on behalf of you since 11/12/22?
No,
Okay. So you have not made any not taken any soil borings?
we have not done any additional environmental phase one site assessments or limited subsurface investigations on the subject parcel since this report was prepared in May 2022.
Okay. Have you taken any samples of the groundwater at the site?
There was groundwater, I believe, sampled as part of this May 2022 site assessment and limited subsurface investigation report.
Have you taken any soil samples?
As previously answered, we have not.
Okay. Were there soil samples taken as part of the 2022 site assessment that you got from Mr. Zobel?
Yes, as identified on page 8, this report consisted of advancement of 12 soil borings and 3 completed groundwater monitoring wells, soil sampling and analysis, groundwater sampling and analysis, drinking water sampling and analysis, and groundwater elevation survey.
Okay. Is it fair to say that other than whatever surveying was done of the property as a result of this site assessment in 2022, the company has not done any further site assessment to this date?
The company's done extensive site surveys.
Or somebody else's behalf? Yeah.
The company has done extensive site surveys. We've cataloged all of the environmental resources, but with regard to additional environmental site assessments, phase 1 or otherwise, the company has not conducted anything in addition to what was conducted on the property in May 2022.
Are you familiar with the term a Chapter 21E site assessment?
I am not.
Okay. Chapter 21E is the Massachusetts Hazardous Materials Site Assessment Remediation Statute. I may not have the fully correct title. Are you familiar that Massachusetts has such a statute?
I am not familiar with that particular statute in the CMR.
Okay. Your colleague, I believe, is an environmental scientist.
Mr. Bergeron is yes, an environmental scientist.
All right. If I could, Mr. Presiding Officer, if I could just, so we could, since it is a panel and we've got the expert here, can I just direct a question or two to him?
Oh, certainly.
Mr. Bergeron, has your company made any, first of all, are you an LSP? Are you a licensed site professional in Massachusetts?
I am not, and our company does not provide licensed site professional or 21E associated services.
Okay. So so no one under your company's aegis has made a 21E survey of this property? Is that right?
That's correct. Our role on this project, and we were contracted sometime in 2024 to provide wetlands resource area delineation for the property, and that strictly limits our services that we provided for this project, other than obviously assisting to prepare this petition and subsequently filing additional wetlands related permitting and or watershed related issues.
Are you aware of any other expert or consultant that has made 21E type site assessments on behalf of Moraga?
Yeah, actually, as part of also one of the things that we did on this project was an advanced due diligence. There was a review of SWCA's proposal by a sub-consultant of ours, GEI.
Okay.
And they just confirmed what was done It was a desktop study with some limited site visit just to confirm the SWCA report. And no further investigation was done. There was no additional phase one site assessments requested of us. And again, Epsilon does not carry that service. We would have to subcontract that service. We were not requested to do so.
So who contracted with GEI to do a 21 East site assessment?
Epsilon carried them as a subcontractor on our initial contract. So again, our focus was wetlands.
Yes.
One of the first tasks that we did was just an advanced desktop due diligence on this parcel, and it just included GEI taking a look at the SWCA report and visiting the site, but nothing more came of it other than that.
Okay. Did they write a report, GEI?
There is a memo, yes.
Do you have the date of that?
I do not.
Okay. Can you provide that, after you do a little diligence yourself into the file?
I can, if you make that a rec request, I can provide that document.
But let's make that a rec request for, perhaps these are already in the file, and if they are, then, in the record, and if they are, I don't need to make a rec request, but I'm not familiar enough with the thousands of pages of documents.
I can check to see if it was included in one of the responses to the hazardous waste, but I don't believe that it is. But if you make a rec request for us to check, I can provide you where it is in the record, or we can provide that document.
That would be perfect.
Yes.
So let's make it a record request.
Right.
And it will have the designation RR-INT-1.
Okay. So the record request, just to summarize, is for for a copy of the GEI 21E, if it's not already been provided, and a copy of the SWCA report, if that's not already been provided. And if they've been provided, you can just give me a reference to a IR number.
The SWCA report we've been discussing today, that's the report provided in the response to EFSB HW 6.
I'm sorry, EFS HW6.
I'm sorry, H-6. And the specific exhibit number is EFSB H-6 parens 1.
All right. What about the other?
I'd have to check the record. That's the one that I'm not sure got included in there. Again, I don't believe it is.
Okay. All right. So then the record, I can amend the record report, Mr. Presiding Officer, to just be for the GEI report.
Understood. Thank you.
So going back to the SWCA report, what did can you summarize whether there were any soil borings that were collected that found any contaminants? In other words, something over non-detect at the site?
Yes, there were none of those reportable. There was no of the soil borings outlined in the SWCA report. No, there were no reportable quantities of hazardous materials found on the subject parcel.
All right. And do you know where those soil borings were taken at the site?
I believe there would be a figure showing. Yes, I have a figure showing where they were taken. It is Appendix E of the report in question.
All right, I'll take a look at that. But you say that nothing was found as detectable in detectable limits. Do you know what contaminants they looked for?
Yes, it is. There is a Appendix F lays out all of the results from the independent lab that the samples were sent to.
Okay. And does the lab report show some type of a suite of chemicals that they looked at? Or something?
Yes, it does.
And can you just, without name me every chemical. Can you just describe the types of chemicals or the types of contaminants that they tested for?
Typically, these reports are looking for the chemicals that would be identified by LSP or by these firms that are required to be analyzed, like heavy metals, for example, things that, if found on site, could be deemed as hazardous waste and require a subsequent remediation.
All right. So heavy metals. What else?
Semi-volatile organic compounds.
Okay. What else?
Are you asking for this specific name of like mercury and lead and nickel and?
So you told me heavy metals, then you told me semi-volatiles. So there must be some other category that they look for.
That's all that I'm seeing right now.
Did they not look for volatile organic compounds?
VOCs are typically looked for in these reports in my experience. I just would need to continue to look here for.
Let's not take up more time. When we take a break, but perhaps you can just look and let me know. And on any of the, so that was a soil. So you're saying none of them came in as detect, correct? Or is it that they were not above certain standards under the Massachusetts regulations?
Correct. The vast majority were ND or non-detected.
Yeah.
There were some results that were detected. However, the recordable limit, the RL, was not exceeded.
Okay. So when you, at the break, if you could just be prepared to tell me, which ones were reported as above non-detect, but below reportable concentrations. Okay.
So, Mr. Reich, just to telegraph this, I don't think there will be a break other than ending for the day, roughly 5 o'clock, just so you can
maybe
prepare.
we can come back. Okay. And then finally,
I'm sorry, just a second. I've got a slight issue. Just a second.
Sure.
It's not.
Just a moment. Okay, Doc. Thank you very much.
Thank you. And Mr. Brock, if I'm going too fast, please.
You're not. You'll hear from me if there's a problem.
Okay. So, Mr. Benito, going back to the report, we talked about the 22 report. Were the groundwater, I think you said there were groundwater tests done?
Correct.
And do you have, are those shown in that report, the results?
They are laid out in this report, yes.
And does it say what categories of chemicals they looked at?
They looked for metals.
Right.
They looked for petroleum hydrocarbons.
Okay.
They looked for semi-volatile organic compounds.
Yeah.
It appears that that's what they looked at.
Like you don't see any listing for volatile compounds?
Perhaps if you could provide me with the name of a volatile compound you're interested in, I could look. It's laid out here.
Trichloroethylene, trichloroethane, vinyl chloride, any of those. Toluene.
Pyrene, what you said, pyrene?
No. I didn't, it says toluene. Toluene.
I would have to, I'm sorry, so I'm not an LSP, so I'm just flipping through this report the best I can, and I don't see those specific compounds or
Thank you.
compounds.
All right,
like
let
those.
me cut to the chase. This site was formerly used as a auto salvage and kind of a junkyard. Is that correct?
That is correct.
And in the process of, and would you expect if a junkyard for old cars, where the cars are taken apart and things were, dismantled and fluids were, fluids leaked out of the equipment and so forth, wouldn't you expect there to be volatile organic compounds found in the soil and the groundwater of a site like that?
I don't know what specific activities were done with regard to those business interests. What I do know is what we talked about earlier, which is the document I have access to that requested those activities you just listed were not going to happen on site. So my understanding based off of the permit that we have, that the applicant stated that there would be no oil changing on site. So that's the only data point I have, sir. I do not know prior to that permit application that we obtained through our DD, if that activity.
I'm sorry, so that we obtained through our what?
Due diligence, sorry. If those activities were conducted on site, or if those activities by those previous owners were similar in nature to what we do know, which is the permit application the town approved specifically stated those activities were not happening.
Right. So if the town, without speculating, but just to use the term that Mr. Pucci used, common sense, would it be common sense that if the town entertained and approved a permit that provided specifically that no oil changes and no other similar projects would be undertaken, that they must have been responding to, a problem that likely occurred under the prior ownership?
I would be hesitant to speak for the town or their planning commission's knowledge of historical uses of the subject property that we are discussing today.
Fine. All right, let me do my notes for a second here. So going back to the site again, does the site have any, is the site under any notice from the Department of Environmental Protection of Massachusetts regarding site contamination?
I am not aware of that, the project being under that or subject to that.
All right. Mr. Bergeron, can you confirm whether it is, whether you know or not, whether it's subject to what's typically called a notice of violation or a notice of contamination? NOI usually.
I have no knowledge of any current 21E related cleanup on the site. However, again, as per the record request, I'd like to go ahead and go back and look at the due diligence that was performed by GEI to see what their conclusions were. I don't believe there are any.
Okay. Mr. Presiding Officer, just give me a second if I could look at my notes here. I wanted to switch gears a little bit to the traffic discussion that the EFSB questioned about. Mr. Benito. Can I ask you a question? Yes.
Yes, sir. Sorry, I was.
Okay. Do you have any information on the approximate size of the trucks that might be entering the entrance road off of Coldbrook Road, and then going up to the site during construction?
Yes, the size of those vehicles are detailed in the spec sheets provided to us by the battery manufacturer, and consists of what is commonly referred to as a tractor trailer.
Okay.
Flatbed tractor trailer would be carrying the battery units.
And how long would that flatbed have to be to accommodate a BESS unit or units?
Yeah, the best units, 28 feet, 10.5 inches. So my presumption would be at least that.
Okay, at least 29 feet long.
Correct.
And then, but that's just the bed, right? You also have the cab of the truck?
Correct.
Okay, and how big are typically how big would the cab be in height, length, width?
I'm sorry, sir. I don't know. I don't know much about tractor trailer cabs. I do know there are varying sizes just from common sense driving on the highway. Some have beds in them, some don't. Some are.
All right. You've been dealing with this BESS project. So have you ever seen a tractor trailer with a flatbed of about 29 feet?
I have seen tractor trailers. I have seen photos, and I have looked at the spec sheet showing how the batteries are positioned on those flatbed tractor trailer trucks.
I'm sorry, how the batteries are what?
How the batteries are situated on those flatbed tractor trailer trucks.
Okay. So you've given me a length. What is the width of the type of tractor trailer that would be hauling BESS batteries up into the site?
Approximately 5 feet, 5 inches, 65 inches.
Okay. You had testified, or maybe it's in the IR responses, that the company or its consultants have done a so-called sweep study, if I got that right, of what is a sweep study again?
A sweep study is an exercise conducted by our engineering firm, or a engineering firm, that analyzes and calculates the turning radius required for a various equipment to make a turn.
Okay. And was that sweep study done, was that a modeling study, or did they actually go out to the site and to the entranceway and take pictures and take measurements and so forth?
Unfortunately, I don't have those reports in front of me to reference. However, I believe we have a record request to provide those, and will provide those where all that information will be laid out.
All right. It's just so I can confirm with the, you have a record request to whom? Sorry.
Yeah. Hold on one sec. Let's figure this out.
Sure.
Okay, yes, sir. So I was just reminded by council the record request is EFSB 4. However, I believe you'll be able to get answers to, I know you'll be able to get answers to this line of questioning with my subject matter expert, the professional engineer that was overseeing that effort, is here to testify.
Mr. Reich, if I can jump in here, it is 5 o'clock, so I'm wondering how much longer you think your cross-examination will take for day one and day two topics?
Not more than about 10 minutes.
Then
Depending on the length of the answers, of course.
I would be in favor of continuing past 5 to accommodate that. Any objections from anyone? All right,
No.
please
Thank you.
proceed, Mr. Reich. Thank you.
So the professional engineer will provide that information. Do you know whether the professional engineer actually went out to the site of the entranceway to the property to make this calculation?
I do not know, but he will be here to testify on Friday, and he will know.
Okay. Have you been out to the entranceway off Colebrook Road to the site? Have you ever seen that in person?
I have been physically to the site. Yes, I've been physically to the site.
All right. Are you familiar with the Danielle and James Stevens' property that's located at 360 Colebrook Road?
I am.
Okay. And is that property on the same side of Colebrook Road as the entranceway to the site?
I believe it is, yes.
Okay. Have you had a chance to look at any of the pictures that were entered into the record on behalf of the Stevenses?
I have not seen all of the pictures or the pictures associated with that record request.
Right. Do you know how wide Colebrook Road is?
I do not know how wide Colebrook Road is.
Okay. I mean, is it 100 feet wide, 50 feet wide, 20 feet wide? You know,
I don't know, sir, but my subject matter expert will have that figure for you.
Have you driven on Colebrook Road?
I have.
Okay. Is it more than a 2-lane road?
If my memory serves, it is a 2-lane road.
Is it fair to characterize it as a rural road as opposed to a highway?
Without being too difficult, I'm not sure what the definition of rural is. I do know that there are state highways and there are federal highways, and I would feel very comfortable stating that this is not a federal highway. However, I have seen many state highways that are similar nature, in my opinion, to Colebrook Road.
All right. Are you aware that on either side of Colebrook Road in the vicinity of the entranceway to the site, there are earthen / metal walls on each side, fairly high, maybe 6 feet or higher? Are you aware of that?
Did you say there's metal walls on?
Metal / earthen. They're made of,
I'm sorry, you were talking on top of each other. I didn't hear the beginning of the question.
Metal and earth, built up walls.
I do not recall metal or built up walls on our subject property.
All right. Since you've been out to the site, you've seen where the Stevenses live. If I have you assume that there are metal walls and that they're metal earthen walls that are higher than 6 feet on either side of the road adjacent to the entrance to the site, would you agree that it would be difficult for a almost 30-foot long tractor trailer, not counting the cab, to make a turn off of Colebrook Road onto that entranceway without being able to back up somewhere on either onto the Stevenson's property or somewhere else because of the fact that there's this barrier on either side of Colebrook Road? Would you agree
I would not agree with that. My subject matter expert has not informed me of that limitation or challenge, but I would reiterate that he would be best suited to answer that question.
All right. The trucks that we're talking about, are they, without going into specifics, are they noisy?
The trucks that we're talking about generate typical noise of similar mannered trucks and vehicles.
Okay. When they're backing up and they have, typically they have backup noise, is that yes, is that noisy, to use a colloquial term as opposed to a specific science term? Is it noisy?
I believe noisy is subjective. I have been around a lot of backing up beeping in my career, and I would not consider it noisy. However, I am also aware that others with different hearing sensitivities may consider it noisy.
Would it be fair to say that ordinary citizens, not people that have had your industrial background, might find one of these 30-foot trucks very noisy when they're trying to back up and turn around in a small space?
Sir, I don't have my noise expert available to me, and I do not know the definition of very noisy, unfortunately.
Okay. I mean, thank you for not answering any of these questions in a very common sense way. Next, do you think it's possible for the company, through its contracted trucks, 30-foot trucks, you think it's possible for the trucks to make the turn? It would have to be either a right-hand turn or a left-hand turn, depending on which direction they're coming on Coldbrook Road, but it's a 90-degree turn, correct? To get onto the entranceway? Do you agree
I
with me?
think that this question would be best answered by my subject matter expert on Friday.
Okay. Do you agree it would be a 90-degree turn they'd have to make to get off Coldbrook onto the entranceway?
I would not agree with that.
Okay. All right, we'll leave that for the expert. Do you, in your opinion, will the trucks, when making that turn, need to encroach on the adjacent Stevens's property in any shape, shape or manner, in order to make that turn and then proceed up onto the site?
My subject matter expert has informed me that the vehicles that you speak will be able to turn into the property without encroaching upon your client's property.
All right. Are there any other trucks that are expected to go onto this property, onto this site, either during construction or operation, different from the 30-foot long truck you're talking about?
Tractor trailer truck that I'm talking about would represent the largest or longest vehicle that I can think of that would access the site.
Will the site be accessed by a crane?
There will be a crane on site, yes.
Okay. And about how tall would that crane be at its top height?
I don't have that information in front of me, but what I do know is that these batteries are required to be placed by a crane that is detailed and spec'd out by the OEMs.
Okay. Is it fair to say the crane is likely to be taller than 30 feet?
Again, sir, I just don't know much about how cranes operate or the dimensions of cranes.
And who on your team would have that information?
I would have that information if it were in front of me. I just don't have Tesla's, in this particular case, Tesla's specification sheet that lays out the size requirements of all of this equipment that is needed to move their batteries onto the project.
But is there another expert or another witness on your company's list? Sorry, I'm a rider's company list that would have that information?
The subject matter expert on Friday may have that information due to the fact that they have analyzed presumably various sizes of equipment to get that swept analysis completed.
If that engineer doesn't have that information, is there any document that's currently in the record, either in response to information requests or otherwise, that would answer that question about the size of a crane? that might
Please
happen?
just give me a moment to check.
Yes.
Yeah, sir, I don't believe we've added it into the record. It may be covered under NDA for us. I'm happy to check and we'll have the ability to provide you with a more concise answer on Friday.
Are you, is the company going to claim some limitation based on an NDA in responding to a question about the size of a crane that might
No,
put up?
No,
No,
we will not.
I didn't think so. Okay. All right. So we might get that information on Friday. Other than cranes and
one point of clarification. You
Yes.
will get that information on Friday.
oh, that's good. Okay. Fabulous.
It will come, if it's under NDA, it will come verbally. So I will look that information up as discussed here, and I will get back to you with that crane size on Friday.
Like I believe that Mr. Kaplan just said it will not come under an NDA.
No, I said, we're not gonna argue that it's an NDA, it's a crane. We'll find out what the size of the crane is.
Okay.
It seems to go by your explanation or by your, it seems common sense to me, so we will find out.
I would hope it's common sense that it won't be subject to an NDA. Are there any other large pieces of equipment comparable to a crane or to a 30-foot long flatbed that will be going onto the site either as part of the construction or as part of the operation?
The transformers will be delivered on a similar vehicle.
Okay.
That's the only other piece of equipment that would come on a flatbed-like vehicle, a flatbed-like tractor trailer vehicle.
And do the transformers need to be installed on the site using a crane?
I will have to get back to you on that. I do not know if transformers are required like the Tesla batteries to be installed via a crane.
Okay.
I'm happy to go late, but I need a break very soon.
Well, I think I'm about to finish up. Let me just take a quick look at my notes. So let me switch gears for a second. You had said something about in your earlier testimony, you had said that the company will do whatever the state requires in terms of remediation at the site. Am I recalling that correctly?
I believe what you're referring to in my testimony was in response to the siting board's questions asking if we would comply with an enforcement action on the property if one were to be issued, to which I replied, yes, we would.
All right, I'm asking you a different question. Assuming that you get full ownership of this property, it really doesn't matter whether you get full ownership. Right now, you have control of the property. Are you aware that under the state's laws, you could be considered an owner or operator responsible for cleaning up the property, even if you didn't contaminate it?
I am aware that
Okay.
Contamination of properties that are contaminated, that responsibility transfers with ownership. Yes.
Does Moraga intend to?
Mr. Reich, I want to be respectful of our stenographer, and there will be an opportunity on day 3 of hearing for you to ask additional questions. So I think we probably should wrap up, and I have a few procedural matters that I want to discuss before we end today's hearing. Mr. Brock, are you okay with another
Sure,
5 to 10 minutes? All right.
Sure.
A few items. So going forward, to the extent that parties, attorneys are referring to specific documents, I would ask that the attorneys specify the designations for those documents so that the witnesses can refer to those documents. I understand there were times when the attorneys were asking general questions that weren't in relation to specific documents, and that is their prerogative to do that. But to the extent they are referring to specific documents, please have the designation numbers ready. I would ask, in this case, the company to prepare a rolling list of the record requests. And you may certainly consult the transcript once that has been provided so that you can ensure accuracy of the record requests. But
You
I
want
think
us to provide that to you or just internal?
I think it would be useful for you to provide it to the service list so that
Okay.
everyone has it. And I'm thinking you could provide that by the end of the day tomorrow. Does that
Yes.
sound reasonable?
Yes.
And just to be clear, the response dates for the record requests are going to be a week from the day they're issued. And so that those responses will be due on a rolling basis. And Attorney Kaplan, if you could, have the record request number and the date it was issued and also the substance of the request, please.
Yes, of course.
Mr. Pucci, I believe you're going to submit the approval from the Attorney General's office. Please do that sometime by the end of the day tomorrow. Looking ahead, we've largely covered day one and day two topics, though I understand there are some remaining questions on the issues of traffic and hazardous materials. Do I have that right? Those are and sound as well.
Zoning.
Well, Mr. Reich, will you have any questions regarding zoning?
I profess to have a lot of talents, but zoning is not one of them, so I do not.
Okay, so is it fair to say that the outstanding issues that require follow-up from day one and day two are traffic, sound, and hazardous materials?
Let me just look at the list that you sent around.
From my perspective, as long as there's a response to the record request that was generated by the siting board today on the traffic issue, I really don't need to ask more questions about that.
Okay.
I think your summary of what's been covered and what's to be covered is accurate. Thank you.
Okay. Let me just consult with my colleagues here for a moment. Okay. I want to preview Friday. We will allow, actually, what we would like to do on Friday is start with the day three topic. And we envision that the board staff will ask its questions. So day three topic has wetland issues, water issues, stormwater. And then when the town is asking its cross-examination, which we may or may not get to on Friday, and when the non-town interveners ask their questions, they may at that point address the remaining questions on the day one and day two topics that I identified that still have outstanding questions. I want to confirm with Attorney Kaplan, please, that whether you will have your safety expert available on Friday.
Yes, can.
Would you repeat that answer?
Oh, I said, yes, we can, if you'd like.
Yes, let's plan on that. Both because safety issues might come up in the context of the wetland issues and other water issues, and also because we may complete our questions on the water issues on Friday.
Okay.
Just one more second. And then I just want to check in one more time to see whether the South Bays are present in the hearing and ask if they have any questions that they will be asking on Friday. All right, so I don't believe they are present. We will convene again on Friday at 10 a.m. Let me just check with my staff one more time. Yeah, so we're good. We will see you on Friday off the record. Thank you.
Thank you.
Thank you.